Original site any mentioning? Related any mention?
Yes. Lord, may I, my lord, kindly to mention, my lord, item number 2 of my lord's appellate side list of today, my lord, under the arbitration.
Commercial or non-commercial?
Non-commercial arbitration appeal.
Non-commercial. Yes.
Item number 2.
Friends Engineering. Yes.
I appear for the appellant, my lord.
Yes.
Mr. Surajit, I am led by Mr. Devashish Kundu. There's a request from Mr. Kundu, man, he wants to do this matter physically, appearing in this court. His request, my lord, if Lordship kindly fixes the date and time so that he can come. He's on a wheelchair, as Lordship knows, my lord. And I've talked to the other side.
Normally, we don't fix time, but yes.
Because of this, my lord, the difficulty is to come with a wheelchair, my lord.
You tell us. Hey,
first week of July, my lord, exceeding 4th July.
First week, who is you're the other side?
Yes, yes. My lord, Mr. Surajit Nath Mitro is reading Mr. Naunchand Bihani. I had a word with Mr. Bihani last week.
What do you mean, Mr. Naunchand Bihani? He is not Naunchand Bihani.
I'm his chamber junior.
July.
Accepting 4th, my lord, Mr. Bihani has difficulty on 4th of July, he told me.
Very well.
So any
July
other day in first week of July, my lord?
3rd July.
3rd July. Lordship. Kindly fixes the time, my lord, 2 p.m. or whatever suits your lordship.
3:30. Original check, dekho. Nahi. It's a Thursday, so 3:30 is safe.
Lordship. 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 Yeah.
Original site commercial, item number 1.
This is my appeal, my lord.
Oh, 1, 2, 3.
My lord,
This matter, my lord, is appearing at my
Original site. It's a commercial or non-commercial?
the commercial matter, my lord.
Vodafone idea.
Yes, my lord.
Yes.
This is appearing at my instance. My lord, this was the order appointing the special officer, my lord. Both the advocate on
Advocates.
records of both the sides were appointed special officers.
Who has changed now?
Now, my lord,
Some of them have changed, my lord.
so far as our person was concerned, my lord, he has changed, and my lord, we want in his place instead, my lord, Mr. Naimesh Tiwari. I'll just give
You are
a-
who?
My lord, I am Indian Performing Rights
IPR.
Society Limited. My lord, that name somehow is not appearing in the list,
Yes.
in the cause list.
But or if your lordship considers the order by which, my lord, the
I believe you.
Oh,
20
take-
seconds.
grateful.
Attack to the other. We want him to be instead of Kushal Gupta.
Yes, we are not applying my mind because
No, it is only
just
this change.
Only this one.
That is all.
you.
My lord, this is the name, my lord. We want
Oh, I see.
in
Sure.
place instead of Kushal Gupta, my lord,
Yes.
we want Mr. Naimesh Tiwari to be appointed, my lord,
Very
as a
well.
joint special officer.
Issue.
Order will be in item 1.
Yeah.
By an order dated May 22, 2024, এটা কি হচ্ছে আলাদা আলাদা হবে?
This will only be
Only
in
in
item number 1.
ও only in item number 1. এরকম কেন রেসপন্ডেন্টের নাম ছাপেনি কেন? না জিজ্ঞেস করবে এগুলো এগুলো যদি আমরা কেউ না খোঁচাই, হ্যাঁ, somebody is responsible, বলবে I want an answer. Item 1 এ হবে খালি. By an order dated May 22, 2024, a coordinate bench had appointed the advocates on record of the petitioner and the respondent. Petitioner bracketed the Vodafone Idea Limited and the respondent bracketed the Indian Performing Right Society Limited. এখানে আছে দেখবে, bracket closed, as joint special officers for the purpose of discharging the duties mentioned in the said order. Paragraph. Today, learned advocate for the respondent tells us that there has been a change of advocate on record,
The instructing advocate. my lord.
instructing advocate on record, change of instructing advocate on record, stop. Mr. Kushal Gupta has given change to Mr. Naimish, এইখানে নামটা আছে, Naimish Tiwari. ঠিক আছে? Stop. Therefore, comma, the name of Mr. Tiwari should be recorded in the place and stead of Mr. Gupta as the Joint Special Officer. Paragraph, we accordingly modify the order dated May 22, 2024, only to the extent that the name of the advocate on record for the respondent be changed to Mr. Naimish Tiwari from Mr. Kushal Gupta.
There are only
So the
one
other
thing.
portions of the order, said order, remain unaltered.
That order was also, my lord, subsequently modified by a 10 July order, but nothing with regard to this.
Only one thing, my lord. Both Mr. Raichaudhuri's advocate on record and my advocate on record are actually not these persons. They are the instructing advocates.
ও যেখানে অ্যাডভোকেট অন রেকর্ড বলেছে
Because
এগুলো
the
ইনস্ট্রাক্টিং
advocate on record continue to remain the
অ্যাডভোকেট অন
same.
রেকর্ড বলবে না, ইনস্ট্রাক্টিং অ্যাডভোকেট।
Yes.
যেখানে যেখানে অ্যাডভোকেট অন রেকর্ড বলেছি, ইনস্ট্রাক্টিং অ্যাডভোকেট বলবে। They are instructing you
Yes.
materially also.
Yes, my lord, materially. I'm sure Ms. Daga will take care of my material instructions.
Very well. What about the other
But,
Vodafones?
2, 3, my lord, they can stand over.
can
my lord,
stand over.
If they can let us know, my lord, any date, my lord, if this appeal can be fixed, any date subject to Mr. Mukherjee's convenience.
Tell us.
Because
These
Mr.
paper
Mukherjee-
books are ready.
Yes, my lord. Paperwork,
Paper books are ready.
Yes, yes,
They should
everything.
appear under the heading appeal from order or hearing, whatever.
Let them indicate Mr. Mukherjee's.
Tell us,
convenience.
Mr. Ghosh, Mr. Sharkar, you are assisting Mr. Ghosh.
Yes. My lord, any day, my lord, June 30, July first week, first or second week.
Yes.
No, second week.
Very well. Bolo, Kaushik, দিয়ে দাও।
My lord, July second week, because I believe Mr. Raichaudhuri is also.
Yes,
Both. Mr.
9 July,
But, instead of 9th, my lord, it
Uh,
would be, my lord,
11 July, 14
yes,
July, 11
14th,
July,
my lord, 14th.
very well.
14 July. তাহলে দেখো, let this matter, paragraph করে, না, তার আগে দেখো, we are told that paper books have been filed. Stop. The appeal may be heard out. Stop. Let this matter be listed under the appropriate heading, Kaushik, appropriate heading on July 14, 2026. 2027.
I'm happy. There's no, I'm complying with the order. I'm happy.
No, my lord, my lord, need the money. That's the only thing.
ঠিক আছে।
Item
আচ্ছা।
3 also, my lord, should appear with it.
2 আর
1, 2
3টা
is-
জাস্ট তুমি 14 জুলাই করে দাও এটার সঙ্গে, আমি আর কিছু অর্ডার দিচ্ছি না।
Great.
হ্যাঁ, দুটো অ্যাডভোকেট অন রেকর্ড কথাটা খালি চেঞ্জ হয়ে যাবে টু ইনস্ট্রাক্টিং অ্যাডভোকেট, যেখানে যেখানে ব্যবহার করেছি কথাটা।
Item number 4,
4 is my appeal. The appeal from an order passed by the registry in a rectification proceedings. The the registrar's order was challenged before this court, and that challenge was also rejected. This is the appeal arising out of that rejection.
So the appeal has to be heard.
Yes, the appeal has to be heard. All the
Paper books are ready, no? File informal paper books. No scope for any interim order.
I understand. Very
Do that. We'll dispose of the stay application. এসো, এই দাও, মেমোটা দাও।
Delay আছে নাকি? Delay আছে? Delay আছে?
There's a prayer, handwritten prayer.
এই,
আমাদের appealটা কবে ফাইল হবে? হ্যাঁ, it's within 10. Right now, হ্যাঁ,
of trademarks, comma, rectifying the trademarks register to the prejudice of the present appellant was challenged by this appellant before a learned judge of this court by filing IPDTMA /13/2024. Stop. That application was, you call it an appeal or application? What do you call
No,
it?
that's an appeal.
Appeal. That appeal was dismissed by the learned single judge by the impugned judgment and order dated March 3, 2025. Hence this appeal. Paragraph. There is no scope for passing any interim order. Stop. The appeal has to be heard out. Paragraph. Let requisite number of informal paper books be filed by the appellant within
2 weeks. 2 weeks.
2 weeks from date, bracketed date ta diye debe, comma, incorporating therein all papers that were available before the learned single judge. Stop. All formalities are dispensed with. Stop.
There is a delay of 7 days
Yes,
on
Malad,
their part.
there was a 7 days delay, Lordship.
Is there a separate application? No.
No, Malad, same application I've prayed for prayer A.
আচ্ছা প্রথমে বলে দাও তাহলে একদম গোড়াতে বলে দাও there is a delay of 7 days in presenting this appeal. Stop. Causes shown being sufficient, the delay is condoned. তারপরে যেটা বলছি চলে এসো ফেরত চলে এসো কি বলেছি last? All formalities are dispensed with. Stop. Since the respondents, when you are the private respondent,
I'm the private respondent.
normally the registrar appears in these matters.
I'm sorry, Malad.
He is appearing on.
Oh, you are
The
appearing.
registrar is appearing.
Oh, since the respondents are represented through learned advocates, comma, notice of appeal is deemed to be waived. Paragraph. The stay application stands disposed of. Stop. However, comma, a copy of the stay application shall be included in the informal paper book for the purpose of reference. Stop. Paragraph. Let the appeal be listed under the appropriate heading 3 weeks hence.
But instead of 7 days, it would be 1 day.
It will be
It would be 1 day. But,
1 day's delay.
officer.
Bojo. 1 day. This delay of 1 day.
My lord, that's the calculated first instance. Then they told me 1 day.
I see.
Grateful, Malad.
Highly obliged, man.
Item number 5,
Item number 5 will also by appear on behalf of the appellants. It's appearing in my instance. I'm challenging an order dated 29th April 2025 passed by a learned single judge of this court, revoking the leave granted to me under Section 12A. Well, also today I am just praying for the appeal to be admitted. I'll just indicate why. Mr. Sumon Kumar Datta is leading me in this matter. He is not in town today.
Mr. Chakraborty, at huge cost, we have installed these microphones. Please use them.
I apologize, Your Lordship.
Yes.
Your Lordship, if I may just...
Yes, Mr. Shumon Datta, I've heard.
Yes, Your Lordship, just the limited conspectus here. This suit was instituted in the year 2021. It's a suit for money lent and recovery of money lent in advance. Your Lordship, now after this order has been passed, revoking the leave granted to me under Section 12A, Your Lordship, there's a judgment of the Supreme Court that I'm embellished with, which says that for suits which are filed prior to the date 20th August 2022, those suits, once the leave has been granted, it cannot be revisited. The second aspect, Your Lordships, is that if the contemplation ever arises, the said suit, if the possibility of mediation still exists, the suit must be kept in abeyance, and thereafter, after a
But
period...
this is Patil. No.
This is not Patil in automation. Patil has been affirmed by a judgment of Justice J.B. Pardiwala, Your Lordship. I'll just indicate the...
Very well done.
First
Today we are not hearing the appeal. So,
Your Lordship, the only issue is that I don't have a stay application here because there's no possibility of a stay. So, Your Lordship, I need to bring on record the
informal paper book.
common paper book, Your Lordship.
Mila, the appeal, Mila, the order is not appealable. Mila, it is barred, Mila, under Section 13.
Very well, argue that.
That-
We'll record your objection. It will be left open. a paper ye dao, memo dao.
Because millet, the revocation of millet section 12 leave millet does not come under order 43. And millet, I have judgments of Supreme Court millet. I'm taking the point today. I'm opposing millet the admission because millet this order in that millet is not maintainable at all.
Mr.
At all.
Chakraborty, he may have a point
Your Lordship,
because
I-
latest patent
It's not
wouldn't
part,
apply.
It's part under section 13.
Your Lordship,
And
that
millet, there are several
But
judgments.
how we have heard some of the appeals?
I will
Some
also
may not
embellish.
possibly millet somebody has not raised this point.
Nobody has raised. That's right.
Because millet, if millet takes the section 13 ones of commercial act,
Somebody is being non-suited, and there'll be no appeal.
Supreme Court.
That's of course Supreme Court is there from
Millet-
everything.
Yes. Millet in intra-court appeals are not maintainable. Millet kindly takes page 30, millet section 13 once, kindly.
Don't argue today,
Perhaps
Mr.
it
Dutt
is your
is not
lordship.
there.
Objecting the admission. Millet.
We are not admitting today.
Very well.
We'll keep it next week.
Your Lordship, I am embellished by the judgment of the Honorable Supreme Court, perhaps by dint of MV Polaris, Your Lordship, a judgment delivered by the Honorable Justice Indira Banerjee. This is admissible, Your Lordship.
Hey, lekho. This appeal is directed against a judgment and order dated
29th April 2020.
April 29, 2025, whereby the learned single judge revoked the order dispensing compliance with the requirement of section 12 capital A of the Commercial Courts Act, 2015, and consequently dismissing the appellant's suit. Paragraph. Learned advocate for the respondent says that this appeal is not maintainable. Stop. He refers to section 13 of the Commercial Courts Act, read with Order 43, Rule 1 of the Code of Civil Procedure. Paragraph. Let this matter be listed again. Which day of next week? Tell us.
Mr. Dutt is here every day next week. As per Your Lordship.
Wednesday.
Wednesday.
Tarikh ta diye dao. Under the same heading, when we will consider the issue of maintainability of this appeal.
Well, can it be on Thursday? Like 20.
Can be after appellate site. Thursday kore dao.
Great.
Come armed with all the case laws.
Yes, Your Lordship.
Item number 6.
My lord, I beg to appear on behalf of the appellant. My lord, this is an appeal challenging an order by which, my lord, my application for amendment and leave to disclose additional documents in a commercial suit was rejected. My lord, what had happened? This is a suit, my lord, which we had filed for recovery of price of goods sold and delivered. My lord, we had prepared 2 schedules, the invoices raised and the payments made.
Additional documents is Order 11, Rule 5.1.
Lordship. Lordship.
Yes.
My lord, when we move the
Is it appealable?
my lord,
Does it come under Order 43, Rule 1? Take up. The scope of appeal has been restricted very much in the Commercial Courts Act. Section 13, appeal section, only those orders which come under Order 43, Rule 1.
my lord,
This may not be such an order. Check up.
my lord, my amendment was rejected. My lord, it was a composite application
Yes, composite for what? For disclosure of additional documents
and amendment.
or
of the-
amendment. देखिए CPC दो. नहीं नहीं excluded. So clause 15 doesn't come to your rescue. Orders which come under order 43, order 43 rule 1 and section 37 of the Arbitration Act. Yes. What do you come back? Monday. Come back on Monday. We are not recording anything.
The lordship keeps it on Tuesday, my lord. Monday, my lord.
Tuesday.
Very grateful.
তোমার ওখান থেকে আসছে।
Item number 7.
7, my lord, I am appearing from behalf of the appellant.
7, I appear for the appellant, your lordship. My video is, my lord, off from there, my lord. My lord, am I?
Mundol, Omnito Mundol. He's appearing. He's
Your lordship can see, my lord. Now I am, my lord, your lordship can see me.
Where are you? You are inside a car.
Yes, my lord, on my
we
way.
refuse to off করে দাও.
No,
Off করে দাও.
your lordship can
Maintain
grant me
some
courtesy-
decorum. Please maintain some decorum.
My lord, may I?
Adjourn for 2 weeks.
So, my lord, kindly do not. There is some urgency.
What is this?
My lord, I didn't knew that he was in the car. My lord, I tender my apology. My lord, I didn't knew that, my lord.
Yes,
Have
Mr.
not been served also, my lord.
Serve and come
But
back.
we have served, my lord. I'll serve him. You can kindly keep it on Monday because the arbitrator set the next date on 25th. And bank
So what will happen? Heavens will fall.
bank will be that bank accounts will be attached. That is the interim order under
I knew
section
that-
17.
Very
only
well.
been passed,
Monday.
Monday.
My lord, the other thing is, but I'm putting my lord friend on notice. My lord, this is not is an appeal, my lord, from an order passed by the arbitral tribunal. My lord, normally, my lord, these appeals, my lord, are entertained by the single judge. My lord, these are not heard by the division bench. My lord, this is an
Oh.
appeal from the
My lord, this is
tribunal.
a order passed on
From
section
section
17.
70.
Section 17, not order of the tribunal, my lord, is challenged before the single judge, not because under the act, my lord, the appeal lies before the court under section 21E. So, my lord, that is not the single judge, not before the. As my lord, in fact, Learned Judge has been entertaining large number of appeals, not from an order under section 17. Your lordship has
আমরা
probably.
section 17 থেকে appeal তো
Yes,
শুনেছি
yes,
বলে
your
মনে
lordship
পড়ছে না।
do not normally hear, my lord. It's
Sir,
heard
you
by the
check
single
it
judge.
up. Check it up.
My lord, I'm carrying the book. It's appealable orders. It's given, my lord.
It's appealable, but before the single judge. I'm not saying it's not appealable.
Mr. Sinha is not saying it's not appealable. The forum, division bench or single judge.
My lord, I'll hand him up, my lord, orders passed under section
Kindly keeps
37.
it on Monday. Then kindly keeps it on.
Keep it on Monday. You'll have to go to the single judge.
My lord.
তুমি একটু জিজ্ঞেস করে নাও তো।
Copy টা আমাকে আজকে
আমি
দিয়ে
দিয়ে দিচ্ছি।
For a hearing, item number 8 and 9.
Item number 8 and 9, I am for the appellant, my lord. But here the matter was, initially it was heard by the other bench, but subsequently, my lord, one appeal was in the commercial bench and other was non-commercial, but subsequently my advocate on record had made it in the commercial bench, both the appeals.
Was it heard substantially?
It was, no, my lord,
কিছু
it was
নোটফোট
heard,
আছে?
No, my lord.
notes
It was
of
not heard, my lord. It's coming for the for hearing now, my lord. After being transferred to the commercial bench.
my lordship, the matter was
Who
heard.
are you for, Mr. Sen?
I am for the respondent decree holder.
Who are you for?
We are for the respondent.
Respondent.
He's reading us, lordship.
Yes, so appellant, you are the appellant.
Yes, I am the appellant.
Start.
My lord, some difficulty is there, my lord, because Kindly see the order.
What difficulty?
Order কি আছে?
First matter, we filed our written notes of argument also.
Which order? Last order is an order allowing amendment of the name.
No, before that.
Which order? Tell us the date of the order. What kind of submission are you making?
Order dated 12th of February 2025.
Yes. What is the difficulty? We have not understood.
The difficulty is that, my lord, the of the record is that one of the leader is there, my lord. Yes. But my learned senior, he has refused to appear in this matter for some reason.
So how come?
I need some time so that I can.
Are you suffering any interim order?
No, my lord. I have secured the entire money. I have secured the entire money.
Security will not give them any solace.
I am ready, my lord.
Yes.
I need your
We are granting you time.
some time so that I can come.
Yes, some time is not 2 years.
Next month, my lord. Yeah.
3rd July.
In 18.
No,
Friday,
No.
my lord, takes around Friday.
no. Don't be unreasonable. Friday, if you want, very well. Friday will give you 4th July.
This is the 5th or 6th time they are taking adjournment, so Lordship keep.
Maybe more than that, because the orders that we glance through, all adjournment.
Anyway,
Yes, my lord, appeal has never been heard.
it's 2008 suit, my lord.
Also, it was hard by Justice Singh.
Appeal from decree.
Yes.
It's from
Yes, my lord, appeal from decree, my lord.
It's from 19, one is of 24 degree,
It
Lordship.
was hard, and
Anyway.
subsequently we could not complete our.
We have understood the merits of your appeal. Come back on the 4th of July. Catch hold of some learned senior now.
If the senior does not appear in that case also, my lord, I have some predicament because learned senior, he is my senior. That is the difficulty. Without him, I don't want to.
Let's make one thing very clear. On the next date, we'll dismiss the appeal. All these grounds are, yes.
I'll do.
Very well. 4th July.
Party number 10.
Then we are for the respondent.
Or maybe.
Here for the appellant.
Yes, sir. It is that matter, my lord.
Yeah. Flaring up the gas. But that was heard by the other bench. No, this bench. No.
You're presided by your lordship's bench.
I know. But
We are for the respondent.
Justice Om Narayan was.
Yes.
Yes. Yes, your lordship.
So you have to either start afresh or get it assigned before that bench.
Your lordship, my lord, will be pleased to decide that. My lord, so far as I'm concerned, I'm
Because if I remember correctly,
Yes.
we had heard substantially. Am I note ache na? 27% or something.
Yes, flaring up.
Yes, flaring up.
My lord,
Mr. Mukherjee, Mr. Mitro, it will be better because we heard it in detail. I have my notes. 5-6 matters we have released from this list because those matters had been substantially heard by that bench. And it's just you have to write a letter to the OSD and it will be assigned to that bench. And that bench can be easily constituted because Justice Rai is sitting singly. For example, today at 2 o'clock, we have that bench.
Yes, but only what is falling from your lordship, my lord, we shall abide by it. But what I'm thinking is this: if there is some amount of continuity in the hearing, then perhaps it will be easier for your lordships also to appreciate the points. Isn't it? So,
My senior is also there. I'm sure he will.
What is your, Mr. Banerjee? What is, Mr.
My lord,
Banerjee?
yes, my lord, my
What
lord,
is your suggestion?
my lord, I leave it entirely, my lord, up to my lord and my lord,
ये
Mr.
तो महा मुश्किल.
I'm sorry, my
That's
lord.
no help.
No, my lord, some continuity perhaps, my lord, is required, my lord. We are also, my lord, we
Well,
are,
then start
have an
afresh.
award.
Then start afresh.
My lord, whatever, my lord,
yeah, I'm absolutely in
Yes.
your lordship's hands, my lord. But what I'm only thinking is this: that if your lordships hear it, my lord, there is some amount of continuity, then it will be easier for your lordship to.
Continuity you can have because we can assemble on Fridays or even on other days also
but,
for an hour, let us say.
But this bench is
Very
going
well.
to continue as a regular bench.
For how long, nobody knows. So let's say for 2 days you argue again, this bench changes. At least that.
I am at a loss also. I think that the court is supposed to decide all issues. Let the court decide this issue also. As to whether this is to be heard by your lordships or some other bench.
But I think Mr. Banerjee wants to say something.
Yes.
No, my lord, if my lord, that my lord is of the opinion, my lord, that would have more continuity, my lord. Of course, my lord, it's entirely up to my lords, my lord, what my lords decide.
I think
quite
let
happy.
this be heard by that bench.
That bench. Very.
Yeah.
My clients are very anxious to have the matter heard.
Yes, my clients are also very anxious to have the matter heard.
We are also very anxious.
We are award holders, my lord. We are, my lord, most anxious, my lord.
Though not marked, heard in part within.
Before your lordship, my lord, passes the order. But we were thinking that this bench is continuing. So, and we are.
As you say, start. Further.
Yeah. Ratanko.
Yes, Mr. Whatever.
We start here. What do you say? No, I
Sir,
always
whatever. No, my
consider
lord, sir, whatever you decide, sir. And my lords decide. I have no. We also want it to be heard, whichever way it is heard.
You are the senior most. Take a call.
Because that. Well, very well, man. Let that bench
Yes.
here.
Though not marked, heard in part within inverted comma. Wise. Comma. This matter was heard substantially by another division bench, bracket, paragraph. Accordingly, comma, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. With the copy of this order, just write to the OSD.
We will.
Jointly লিখতে পারি আমরা. Both of us want the matter.
The interim order will continue. Well, the interim order will continue. The interim order, which was extended till the end of June. I believe that is the order dated 8 May 2025.
The interim order that is in operation stands extended till the end of July 2025 or until further order, whichever is earlier.
My lord will only, my lord,
You see, of course. আলাদা করে আমাদের সই করিয়ে নিও যাতে আজকেই লিখতে পারে।
My lord, 15 will be the same,
15?
will be the same order. Fifteen will be the same order.
Yes, we remember in great detail he had argued.
Not only one request, not I have not if it commences to your lordship. Not if that, no, since not that bench has not number of parted matters, not if your lordship not could sit at 3 p.m. not on alternate days, not then.
We'll do something like
Yes,
that.
not if something like that could be
Yes,
done,
we'll
not,
do
then
something
then
like
these
that.
matters not
Yes,
can be
yes.
disposed of expeditiously.
I already have that in my mind.
Very grateful to your lordship.
শোনো 15 এ সেম অর্ডার করে দাও, অ্যাপিয়ারেন্সটা নিয়ে নাও।
Lord, I'll give your lordship not the dates, not when it was heard, so that could also be recorded in that order. Not
তাহলে শোনো ওই যে যেখানে লিখছো heard substantially
on lordship
by heard substantially on বলে যে ডেট গুলো দেবেন দিয়ে দাও, ওই ডেট গুলো দিচ্ছে, লিখে দিচ্ছে তোমাকে। এদের এখানে ইন্ট্রি মডেল নেই।
This bench, it was heard on these 4 days.
4 days. 4 days.
Yes, yes. Lordship, lordship, lordship.
Item number 11.
My lord, this matter was also heard by the earlier bench. My lord, it's the section 12A point. One of the matters involving the same point of section 12A of Commercial Codes Act. My lord has transferred it or assigned, has ordered the matter to be heard by the bench comprising of my lord and my lord Justice Om Narayan Rai. If my lord so think,
বুঝলাম না কি বলছে।
my lord, there was this, like, my lord, this is a matter involving section 12 of the Commercial Codes Act. Like, my suit has got dismissed because of.
এটা কি বেঞ্চ শুনেছে? এই বেঞ্চ দেখি নোট আছে? Same order.
Grateful, my lord.
Item number 12.
Is there an interim order in this matter?
No, my lords.
In this matter, I appear on behalf of the respondent, my lord. I'm being led by Mr. Rajushri Dotto, my lord, who has not come to court. He has requested
12.
12, item number 12, my lord.
12, who is appearing for the appellant?
My lord, I am also being led.
The respondent.
Jitendra Agarwal.
Yes, my lord. My lord, this matter was also heard by Justice Om Narayan Rai bench. But if my lord will grant an adjournment, we can like continue on the.
এই দেখি তো অর্ডার এটাতে।
Involved in the matter, let him come.
My lord can grant.
Requested if this can be taken up anytime after Monday.
Yes, yes, we'll do that. নোটটা কোথায়? No, no. It was only one day it was heard. Only on the 23rd of May.
I'm not.
Come back.
Any after my.
Accommodation is sought for on behalf of the parties. Paragraph, list this matter once again on after Monday, you said. On আজ কত তারিখ 20 June 25.
I'm grateful.
Grateful, my lord.
I appear on behalf of the respondent. Lordship, I was being led by Mr. Joydeep Kaur and Mr. Shuman Dotto. Shuman Dotto is not in town today, and Mr. Joydeep Kaur, Lordship, he is on legs. My lord.
Well, kindly keep it till Monday then. Your lordship will be taking up this list on Monday.
Monday to commercially. On the request made by learned advocate for the respondent, let this matter stand adjourned for the day.
I'm grateful. Yes, sorry.
Item number 14.
My appeal, I was requesting your lordship to keep it, my lord, on Monday. I'm led by Mr. Mitra. He's not in Calcutta today. My lord,
Where is he? Shanghai?
Bangalore.
Bangalore. Not impressed. Yes.
I was only praying, since he is asking, my lord, I would like to file a short affidavit to the application which they have filed.
What application have they filed?
They have filed an application. We have also filed an application. 2 applications have come up. Lord, that has
allow
to
us
be
to
heard
move
to
that application on the next day. I've not moved that application yet, my lord.
Yes, Mr. Chaudhary says that why waste time in the meantime? Let him file an affidavit.
By Wednesday, I'll file my affidavit.
Let him file.
So let it.
Have you filed any affidavit in response to their application?
If they want
to, we have just been served. We've just been served yesterday.
Do you wish to file these instructions? You should have. Then you could utilize this time in filing the affidavit.
Possibly, then, my lord, can it passes it over for 5 minutes, my lord? May I take instructions and come back? I'll just speak to Mr. Mitra once.
Thursday রেখে দাও, তুমি ফাইল করলে করবে, না হলে করবে না. There is no scope of any interim order. Thursday I am asking
once and come back, my lord. I'll just have a or can you
go. No, we are waiting.
Anyway, I'll just speak.
নিজের ঘাড়ে কিছু বন্দুকটা নিতে চাইছে না।
No, 15 has already been adjourned, not 16.
Oh, acha. 16.
Lordship already posted on the other.
16.
Not 16, not as paying for next Friday. Lord.
Next Friday. You're for
I'm the appellant.
Appellant.
My lord, and this
16 act order karo on the request made by Mr. Sinha, learned advocate representing the appellant, let this matter stand adjourned and be listed again on June 27.
And my lord, 17 and 18, my lord, friend, my lord, is for the appellant. My lord, he was to, my lord, file his notes, my lord, which he has not, my lord, given. My lord.
Yes, you said you want to file notes.
Let him give me the notes, my lord. Keep this also next Friday, my lord. Let him serve me.
Give him. You want to file your note today?
My lord, without giving copy to my learned friend, whether, and I want to submit at the same time, my lord. Only.
All right.
I think he's not given it.
17.
I have given to my
I believe it's just come.
17 or 18 act order karo. Learned advocate for the appellants has made over a copy of his client's written notes of argument to learned advocate for the respondent. Stop. Paragraph. As requested by learned advocate for the respondent, let these matters, stand adjourned and be listed again on June 27.
Our notes are also filed, but already on record.
It's already recorded.
No, we have not been served with the notes.
Notes are judgments from the
No, then.
My lord, they are agreeable, my lord, that matter, lordship.
ওই কোনটা ছিল যেন
Next Friday, lord.
Next Friday, my
my
lord,
lord, we'll serve our opposition by Wednesday and reply in the meantime.
14 এবার 14 দেখো করো ওখানে 14
14.
We are told that applications have been filed both by the appellant and the respondents. Stop. As suggested by learned advocates for the parties, let this matter be listed again on June 27, 2025. Stop. In the meantime, the parties will be at liberty to exchange affidavits.
Lordship,
Has joined.
Lordship, I am not here. I wanted to do it physically, my lord. Only thing I was saying, Lordship can hear out the appeal also. It will save my lord's time. For the next day,
Paper
kindly
books
keep.
are ready.
Yes, we
Yes,
have
yes.
informal.
Very well. Very well. Lovely background. Where are you, Mr. Mitra?
Bangalore. You must have stayed here once, wherever I am staying.
Very well. Come back next Friday.
Grateful.
Item number 19.
Didn't want to proceed with the conversation any further.
Their cross appeals. My lord, what has happened, my lord, in the meantime, my lord, there has been a demerger, my lord, so we filed, my lord, an application for, my lord, substitution of Ultratech in place of Kesoram. My lord, in item 20.
That is that GA.
Yes, my lord, the GA1, my lord, in item 20. My lord, the same can, no,
The same substitution in
can
19.
happen in 19 also. My lord, Ultratech, my lord, is, my lord, the solvent company. So, my lord, if my learned friend succeeds, he'd like Ultratech to be the respondent.
You are Keshuram.
I'm Kesoram, my lord, which, my lord, cement division has been, my lord, demerged to Ultratech.
Acha. So we'll allow this application?
Yes, yes.
Application to thou. In both the matters, there are applications.
No, only in, my lord, in my appeal, my lord, which is 20.
But, my lord, the same amendment may be
Same
also
amendment,
permitted in
my lord,
19.
learned friend is, my
Because,
lord,
my lord, it is my learned friend's, my lord, assertion that, my lord, his character has, a persona has undergone a change.
Very well. Item number 20 তে যেটা GA1 আছে। আচ্ছা আমার একটা কথা বোঝাও তো কৌশিক। এই IA নাম্বার GA.com1 দুবার প্রিন্ট করে কেন? মানে কোনো কারণ আছে? দেখেছো লিস্টটা? 19 কোনো GA নেই। ও আছে।
my lord, that's the stay application.
ওটা স্টে অ্যাপ্লিকেশন। ও 20 ক্ষেত্রে তাহলে স্টেও আছে একটা। দুটোই 1 কি করে?
My lord, in 19 there is a stay.
Yes.
In 20 there is no stay.
Oh.
There's an order 41, rule 27 application.
In 20.
In 19.
My lord, in 19 there is a, my lord, for, my lord, additional evidence. Not 20, not for stay, additional evidence. My lord, they have, my lord, made an application under order 41, rule 27 in 19. My lord, which has to be really heard along with.
So there is no stay in 19.
No.
Also in 20 there is no stay. Paper books are ready.
No.
They filed, my lord, paper books.
Saying yes.
Paper book file হয়েছে?
Oh.
Oh.
So common paper.
And now that I have a soft copy, my lord, I don't see the paper book, so it becomes at times a little confusing.
Right
Paper
in
books have
front
been
of
filed.
you, I suppose.
Yes, yes, my lord, paper books are there.
Intimidating. Adjourned for 2 years.
We will, my lord, not take your lordship through those.
কি করে পাওয়া গেল না অ্যাপ্লিকেশন? এই অর্ডারটা লিখে নাও। অর্ডারটা করে নাও তো, অ্যাপ্লিকেশন পাবে না খুঁজে জীবনে, করে নাও।
Copy আছে application, দাও quickly. My lord, I have a copy, my lord, one copy, my lord, I have. My lord, two copies.
Thank you. EACOM 1 of 2025, হ্যাঁ? এটা item 20 তে। Mr. Mukherjee, learned senior counsel representing the appellant, says that the appellant has merged with one
The
Ultratech.
cement division of the appellant has merged with.
The cement division of the appellant, that the cement division of the appellant has merged with one Ultratech Cement Limited. Stop. Hence, this application has been taken out to substitute Ultratech Cement Limited in the place and stead of Kishore. To substitute Ultratech Cement Limited in the place and stead of Kesoram Industries Limited. Stop. Paragraph. Mr. Shaha, learned senior counsel representing the respondent, says that he possibly cannot oppose this application, this prayer, possibly cannot oppose this prayer. Paragraph. Accordingly, there will be an order in terms of prayer,
A and B, my lord.
prayers A and B of the. You have a notice of motion.
Notice of motion.
Of the notice of motion, which read as follows. এখানে দিয়ে দিও, সুবিধা হয়। এই যে A আর B টা set out করে দিও। ঠিক আছে?
This order is being made in item number 20 because, yes.
20. Paragraph GACOM Tom, সব disposed of ওটা।
My lord, let a similar direction be made, my lord, for amendment of the cost title, my lord, serial number 19 also.
The joint prayer, my lord, your lordship, my lord.
19 একটা অর্ডার করো। We are told that Kesoram, the cement division of Kesoram Industries Limited, has merged with one Ultratech. কি জানো Ultratech?
Ultratech Cement Limited.
Ultratech Cement Limited.
Cement Limited. Top. Cement Limited, having its registered office at?
My lord,
I'll give your lordship, my
my
lord.
lord, my lord, this is in my lord Ahura Center.
My lord, Ahura Center.
ওই তো অন্য পিটিশনটাই আছে।
My lord, it's there in prayer A of the notice of motion.
এই যে এখানে আছে।
Ahura Center, B wing, second floor, Mahakali Cave Road, Andheri.
Ultratech Limited, having its registered office at, এটা দিয়ে দেবে। Ahura Center, etc. মুম্বাই এত মহারাষ্ট্র। Stop. Mr. Paragraph. Mr. Mukherjee and Mr. Shaha, learned senior counsel representing the appellant and the respondent respectively,
It's the other way around here, my lord.
no, it's 19.
19, my lord, Mr. Shah is the appellant.
Yes. Mr. Shah, yes, no, I was following seniority. I was trying to be polite, but yes, Mr. Shah আগে বলবে and Mr. Mukherjee, senior counsel representing the appellant and the respondent respectively, jointly suggests that the name of Ultratech be substituted in the place and stead of Kesoram. Paragraph. Accordingly,
Respondent in this appeal.
Kesoram, as respondent in this appeal. Kesoram, as respondent in this appeal. Paragraph, let the department carry out necessary amendment to the cause title of the appeal papers by substituting Ultratech Cement Limited, করে আবার বলে দেবে, having its registered officer such and such, registered officer such and such, in the place and stead of Kesaram Industries Limited, Cement Division. Let the amendment be carried out within a fortnight from date. Paragraph, list this appeal as also AO-COM 7 of 2025, 2 weeks hence, bracketed date ta diye dao. 2 weeks hence কত হচ্ছে? 4th July is all right, just see.
4th July, my lord, is not all right, my lord.
Not all
Kindly
right.
keep it after that, after 4th July.
তাহলে list the matter on 9 July?
Yes.
July 9.
Great.
Well, I was assisting Mr. Mukherjee, my lord.
You have lost weight noticeably, which is good. I'm not complaining.
A lot of things have happened,
Okay.
but the background melody is not exciting.
No, I was talking about Mr. Mukherjee, junior Mr. Mukherjee.
Junior Mr. Mukherjee.
Mr. Bose, why are you not here? Why are you not here?
My lord, I am in another state, my lord.
Bangalore?
No, my lord, I'm in Ranchi, man.
আচ্ছা, ঠিক আছে, রাঁচি। All right. Yes, next, বলো।
Item 21.
Item 21, I appear for the appellant. Mr. Ghosh was addressing your lordship on the last occasion.
Who was it?
Devnath Ghosh was addressing your lordship on the last occasion. He's in some difficulty today. I'm told to pray for an
He's
accommodation.
leading you.
Yes, your lordship. He's leading.
So there, my
Oh, Mr. Dash.
Mr. Ghosh is leading all of us.
When?
Monday, my lord.
Not
For
today.
today's accommodation. He is in court. What is the difficulty?
But he's requested me to seek for
A day's accommodation is sought for on behalf of the appellant. Stop. List this matter once again on Monday date diye dao.
Grateful.
টোয়েন্টিতে জিএ আছে একটা, ওটা ডিসপোজ অফ হয়ে গেল। 19-এ কোনো জিএ যেটা আছে সেটা অন্য জিএ। 19-এ আমি ওরাল প্রেয়ারে দিলাম অর্ডারটা। তুমি পেয়েছো? এটা পাওনি খুঁজে?
Lordship, item 22, I appear for the appellant. May I pray for 2 weeks accommodation, Lordship? We are waiting some instructions. If we can come back after 2 weeks.
What
Lordship.
kind of instructions?
Lordship, whether to proceed with the appeal or not.
I think
Oh,
it's
that.
Yes, Lordship.
nothing, my lord, nothing in the suit was dismissed, my lord, against the claim was dismissed.
No, Lordship, that's not.
Why
it's-
can't
it's
you
a-
take such instruction within a week?
Lordship, because the instructing client, there's a renovation going on in his office, and he doesn't, at present, he does not have access to all his books. That's why. So he's prayed for 2 weeks. So we are praying for 2 weeks' time, Lordship. If your Lordship can accommodate us for 2 weeks.
We were asking
Yes,
the
Lordship.
nature of instruction. Is it material or immaterial?
Lordship, it's material. It's material, Lordship.
Material instruction.
Yes, Lordship. This is with respect. No. The reason why I'll tell. No.
Urgent for 2 weeks.
Grateful, Lord.
কিছু লিখতে হবে না। আচ্ছা, on the prayer made on behalf of the appellant, let this matter stand adjourned for 2 weeks and be listed again on July 4.
4th July.
Non-commercial. phone নিয়ে ব্যস্ত।
এইটা তোমার ইউ করতে হবে, তো ইনিশিয়াল করতে হবে। তাও না, যে কোনো একটা কাজ লিখলেই হলো আবার।
বলা হয়ে গেছে তো।
এটা এক্ষুনি সার্ভার করতে বলো এটা কালকে। এসে গেছে।
রিপোর্টটা কোথায় আছে বলো তো? My lord, volume 3 is also what your lordships would want to see, which is the report. The thrust of to recapitulate. There were, my lord, 3 issues which had come up in view of the judgment which I had addressed. In response, my lord, first issue was that though the period is between 2014 and 2017, a 2018 valuation was used for the purpose of determination by the learned referee, which, my lord, according to Mr. Chaudhary, was wrong, and his objection, my lord, succeeded before the learned single judge. This was the first issue. The second issue was that the learned referee himself went, my lord, to see the property, so he should have taken note of the slums, which he did not. And the third issue was that some construction has been made at the property allegedly, as per the learned single judge's judgment, my lord. Some construction may have been made, so that should also have been considered.
Value added.
Yes. So, my lord, there was a remand, my lord, back to the learned judge, to the learned referee for a de novo consideration after approximately, my lord, 7 or 8 years since the delivery of possession in 2017. It's really after delivery of possession that the exercise pertaining to mean profit commenced. So now to go back, my lord, is an unbearable situation for us, my lord, because we are utilizing the property and we now really want to put an end to this chapter. And we don't know, my lord, whether the defendant, after having successfully warded us for 8 years, ultimately when a judgment comes, whether they'll be in a position to pay. In fact, even in this appeal, in the stay petition, my lord, we accepted the judgment, whatever came. And, my lord, we had applied, my lord, when the remand came, we accepted the report. And when the judgment came for a remand, we had, my lord, filed an application. In the stay petition, we made a prayer that your evidence is it's 43. My evidence was it's 100. Learned referee has found it to be 50. But you say it's 43, your evidence. So at least pay me 43. For the balance, we'll go for adjudication. That, my lord, prayer was not accepted at the beginning of the appeal. So, my lord, the situation today is the least it can go down to is 43, which is their evidence.
They have come up to 46, if I remember.
They had come up to 46 in the course of, my lord, negotiations, but
your client may be well advised to accept. We don't know.
No, I'm accepting 46. I have no problem with 46.
The difference is where?
Difference is they're saying that I won't give you interest and I'm going to pay you over 2 years. We did the mathematics. If, there's no interest, it really goes down to around 32 or 33.
We can't say any further, Mr. Chaudhary, but even without interest, maybe it
accepted.
That would indicate what we are thinking.
Yes.
This 2018 index.
No, I totally appreciate. But
if you want to have another word with your client.
No, he's left it, Willard, and he said that I want to finish it. But finishing at what end? Going down to
yes,
20s?
That has to be your client's call.
Yes, yes. No, but the only hope which I have, and normally I am very pro-settlement, but now, my lord, in this matter, I in fact persuaded him, accept 50, finish it off and go. They appealed on this ground. Now, my lord, 46 also we agreed, but now it's going down to 30. That's, my lord, being pushed far too much. But the saving, my lord, grace, which I feel, which could make the difference, my lord, is my rejoinder submissions. Maybe it will, maybe it will not. We'll have to accept the fate.
Let us proceed and finish it off then.
Yes, my lord. Just 15 minutes. And one factor, my lord, on the basis of which I express this, my lord, hope, is, my lord, Mr. Chaudhary said that the best evidence are the 4 deeds.
Yes.
And he referred to one deed and he said, look, this doesn't add up to even this amount. It adds up to 9 crores. You're proceeding on 10 point something crores as the price of the property. This deed, my lord, shows that the market value of the property is 9 crores. All 4 deeds were, my lord, exhibited. My lord, I have, my lord, those copies with me. They have those copies as well. Chart is set now. This is exhibited in the reference, so my lord, should not be a difficulty, and he's referred to it. Since my learned friends don't have it here in court, my lord, I'm giving it to them also.
ফাইলে করবে, কভার ফাইলে করে এটাও ইন্ডিকেট করবে যে কে ফাইল করেছে, অ্যাপেলেন্ট দিয়েছে এটা।
What is, my lord, clearly overlooked? It's been a long time, my lord, since we did the reference. Is that all are not, my lord? My lord, may I just show your lordship the consideration? My lord, it actually adds up to 11 point something crores. My lord, kindly have a look at my note. I've given the particulars. So let's, my lord, I want, my lord, to go by these documents. If I go by these documents, my lord, and following his submissions, my lord, it even crosses 10 point something which the learned referee has given. So that, my lord, is the saving grace. My lord, kindly have a look at the first paragraph. The first day when he argued, my lord, he took the point that the learned judge, and this is his main argument before the learned single judge also, that let us go by the best evidence. And the best evidence are deeds concerning this property in the year 2014. And he refers to one of them and he says, look, the rate is 9 crores. That's the value of the property. While the learned referee has fixed 10 point something, 10.7 or 10 point something. But what I am saying is that if you're looking at these deeds, they're all executed together. You must see all 4 deeds together. And the value will be much in excess of 9 crores. It will be over 11 crores because the rate is not the same in all the 4 deeds. Lord, Lord, please see my note. By 4 deeds of conveyance executed in 2014, the plaintiff's co-owners transferred their undivided interest in the same property. Market value of 1/4 share disclosed in the indenture dated 2nd May 2014, whereby Ravi Khandelwal transferred his undivided 1/4 undivided share to the plaintiff is rupees 2.25 crores. Then, Lord, all 4 deeds of conveyance are exhibited in the reference. In 2 of the deeds, the value of 1/6 share is 2 crores. In the other 2 deeds, the value is rupees 2.25 crore for 1/4 share. Thus, value of land considering value of 1/6 share of property as 2 crores would be 12 crores. Similarly, value of land considering value of 1/4 share of property as 2.25 crores would be rupees 9 crores. Average is 10.5 crores. So, my lord, in 2 of these 4 deeds, 1/4 share was sold to be by my co-sharers in 2014 at, my lord, rupees 2.25 crores for 1/4 share. And in 2 of the deeds, 1/6 share was sold to me for rupees 2 crores. If you add it up, it comes to 12 crores for the property. So Mr. Chaudhary has taken the minimum rate of these 4 deeds, my lord, taken to, my lord, these 4 deeds are together. The dates are also, my lord, similar. One transaction, co-sharers transferring to me. He's picked up the minimum. I'm not saying pick up the maximum. I'm saying take the average. Even then it comes to 10.5 crores, which is what the learned referee has held.
The referee has taken 10.5.
10.7, I believe, my lord.
7.
10.7.
10.76.
10.76. So, my lord, this is Mr. Chaudhary's argument that the best evidence has been ignored. Look at the deed. Deed is 9 crores in 2014. My lord, I am saying, my lord, with respect, that it can't be the minimum of the 4 deeds. Take it together, it comes to, my lord, average is 10.5. Take it together, it's 12. And it's 2014. So let's take his submission at face value. He says this is the best evidence. So take all 4 together. Even then, that's over, my lord, 50, over what I've got from the learned judge. If you take it all together at 12 crores, even then it's over rupees 51 or what I've got from the learned judge. If you take the average of all these deeds, it is 10.5 crores. Just about the same. 10.5 and 10.7. And this is 2014. Period is 14 to 17. So it becomes justified. The learned judge's finding is justified. Now, my lord, if you kindly...
Learned judge's finding?
Yeah, learned special referee's finding. I'm sorry, my lord. So, my lord, so this 2018 argument, even if your lordship accepts on the basis of Mr. Chaudhary's submissions that the best evidence should be taken, if you go by his submissions also, there is no reason to go by the minimum rate disclosed in 4 documents executed together. If you take the average, I succeed. If you take the maximum, it goes even above what the learned referee has given me. This is the number 1 in answer to, my lord, this argument. And this is 2014. Period is 14 to 17. He can't get more than this. He can't get more than his submissions. Now, my lord, second, if your lordship, I just want to analyze 3 paragraphs of the report and show your lordship that it's totally and absolutely logical. My lord, please, my lord, come to paragraph 2 of my lord note. This is paragraph 1.
Yes.
Paragraph 2 of my note. The circle rate value as on 25th April 2018 is 10.76 crores, which works out to be 62.29 lakhs per kata. This is, my lord, paragraph 67, page 109. Lord, kindly, my lord, take the report once. Lord, আমি কি ভুল করছি? Lord, paragraph 67 of the report. No, my lord, yes. Lord, in 4 paragraphs, the reasoning is given. Lord, please take page 109, paragraph 67. My lord, paragraph 66 is where, my lord, these 4 deeds of conveyances are, my lord, recorded. Now I'll read paragraph 66. There are 4 deeds of conveyance by which Harish Kumar Khandelwal, Girish Khandelwal, Ravi Khandelwal, Uday Khandelwal transferred their respective undivided interest in the suit premise in favor of the plaintiff. Deeds of conveyance were executed in 14. Plaintiff cannot possibly contend that the market value of the property, which is the subject matter of the aforesaid instrument, has not been set forth in the instruments presented for registration, or that the said instruments were undervalued so as to lighten the burden of stamp duty chargeable on the market value. In the indenture dated 2nd May 2014, whereby Mr. Ravi Khandelwal transferred his 1/4 share in the suit premises in favor of the plaintiff, the market value forming the subject matter of the deed was assessed at 2.25 crores. The first schedule is exactly the same as the schedule to the plaint. First schedule as well as the recitals record presence of the defendant to be in occupation. First schedule records the defendant is in occupation since 40 years. The other conveyances are similarly phrased. Now, my lord, the learned judge, learned referee, my lord, uses this to repel my argument that the value should be much, much more. I had argued that at that juncture, my co-sharers sold to me at a depressed value because of the fact that it was under occupation and we were just starting eviction. That argument was rejected on the ground that I couldn't show any law or, my lord, anything to show that the circle rate goes up or stands reduced as per, my lord, tenancy existing in the property. So this is used against me, my lord, to bring it from 100 to 50. Now, my lord, please see what is the logic used by the learned referee in coming to this. Just 3 paragraphs. 67. While it has been contended by the plaintiff that the market value of the property would be depressed in the presence of the defendant being in occupation as a tenant, plaintiff has not indicated to me as to what would be the difference in terms of percentage that the presence of a tenant may make to the market value, did not indicate. So, my lord, I lose, my lord, on this. Towards the last line of the page, last 3 lines, the department assessed the market value of 5 Commissariat Road comprising of 7.28 katas at rupees 10.76, irrespective of whether the property was an owner occupied property or a tenanted property. This is of 2018, produced by him. So, my lord, titled my deeds, my lord, where my co-sharers sold to me 4 deeds. If your lordship takes the average in 2014, it's, my lord, 10.5. And if your lordship takes all 4 together, it's 12. And in 2018, the circle rate, my lord, is 10.76.
If you take all 4 together, it's 12, Pane?
My lord, what has happened?
If you calculate on the basis of that 1/6,
yes,
it comes to 12 because 1/6 was sold for 2 crore.
1/6 was sold for 2 crores.
So therefore, 12.
I'm sorry, I made a mistake. It's not. It's not 9. It's 10 point something.
10.
All 4
5.
together. Yes.
Yes.
10.5. 10.5. And if you take the least value, it's 9. That one document. And if you take the best document for
12,
me, it's 12. So I'm saying, please don't take the best document for me, and please don't take the best document for him.
Fair enough.
Yes. And the circle rate produced of 2018 as noted is 10.7.
More or less matches.
Now, my lord, the plaintiff also during contended, that's my lord, page 110, para 37 at the top. The plaintiff during arguments also contended that the market approach sales comparison method is the commonest method adopted for such and such. You know, same property, identical property, so use it. That was, my lord, my argument. And I had shown, my lord, other examples. Those examples were not taken, which had a much higher rate, but that argument was used to apply these 4 deeds of conveyance. That's, my lord, the end of para 68. Now, my lord, please take the next paragraph. And paragraph 3 of my note, which is a summary of that paragraph. Although circle rate is of April 2018, the same can be used in view of RW1's evidence in questions 14, 18 and 54. Your Lordship has seen the questions. Now, there has not been any major price escalation. And if your Lordship sees the paragraph, circle rate is applied. Although circle rate of April 2018, I feel that the same could be profitably used in arriving at the fair market trend. This is because RW1 has himself deposed that valuation has not increased much between, and the questions are referred to. Now, my lord, this I've addressed. Now, the next thing. In his valuation report, one of the scenarios depicted by RW1 is to consider fair market value and fair market rent of the suit premises concerning the 4 deeds. He has proceeded to arrive at annual fair market rent of 74 lakhs such and such, corresponding such and such. RW1 says market price of similar type of land in the locality. Now, this is important. My lord, the learned referee looks at 2 price bands based on, my lord, his evidence. My lord, please see 4 lines from the top at page 38. RW1 says that the market price of similar type of land in the locality in May 2014 can vary from 45 lakhs to 65 lakhs per kata, but that he has considered the market value of the suit premises to be 52 lakhs per kata due to its irregular shape and location. So May 14, his witness says price band is 45 to 65. And his witness has selected 52 because of irregular shape and slump. And then, my lord, it's 8% applied. RW1, then, my lord, a few lines down, RW1 has carried out a similar exercise for determination of market value as at the date of the report. My lord, date of the report is 20th April 21. And he says it's now 55 to 70. Now, if your lordship reads on. But he's selecting 60. So, my lord, he selects, my lord, 2 price bands, one in 14, one in 21. Then, my lord, paragraph 70. This has, my lord, additional justification. The 2 valuers, CW1, RW1, have both used circle rate for determination of market value. Although not much in the way of objection can be raised with regard to the manner in which RW1 has taken depreciation. I find some difficulty in accepting market value of the land to be 52 lakhs in May 14 and to be 60 lakhs within 3 years thereafter, despite the clear evidence of RW1 regarding the fact that between 2014 and 18 there has not been any major price escalation. I dare say that the computation made by RW1 would reflect a more reasonable estimation of fair rent in May 14 if one considers the market value of land in 14 to be 62 lakhs per kata. This would be, this is additional justification. This would be well within the price range mentioned by RW1 in part 2 of his valuation report. So, my lord, within the price range. 2, again, this would not be based on mere whim or ipse dixit, but based on the valuation carried out by Directorate of Registration and Stamp in 2018. In taking the conveyance into account, there is no fallacy, and, my lord, it's accepted. So, my lord, if your lordship looks at the determination, it's within the price band, it matches with the conveyance, it matches with 2018. It's, my lord, one sentence cannot be taken out in isolation. My lord, there are several reasonings and justification. Yes, one of them is the 2018 document given by them. But if it was inapplicable completely, why did they give it?
We need to hear Mr. Chaudhary on this also, because this is really from a different angle you have today made a submission. which makes sense, Their grievance is that the special referee took the market value to be 10.76 crore as in 2018,
Yes.
beyond the relevant period.
Yes.
They say, why did he do that? There was best evidence available. 4 deeds. 1 deed is shown to us. 1/4 sold for 2.5. So therefore, the entire property is worth 9 crore.
Yes.
That should have been the market value. Now that you have shown us all 4 deeds, it should come to 10.5, taking an average. 10.5 and 10.76, not much difference, almost the same. So where's the problem? This is for your consumption and response.
And further justification within the price band.
Price range, as per your witness.
And lastly, my lord, if 2018 was so irrelevant, why did you bring it as evidence? And my lord, in my lord defense of Mr. Chaudhary,
2018, who were brought in?
he brought in evidence, his valuer brought.
His valuer.
And my lord, this is just one of the deeds. It's not referred, my lord, the other 3 deeds are not referred to in the report. So to be fair to Mr. Chaudhary, my lord, it is, my lord, there's justifiable reason in missing the other 3. In fact, I was also not aware, my lord.
Do you have copies of the other?
I've given them now. And these are exhibited documents.
Mr. Chaudhary has left court, my lord. He has requested that in case he has to respond, my lord, it can be any.
This is, we'll keep it. That's all?
Yes, yes.
When?
My lord, apart from
Wednesday. এই Wednesday এটা কি commercial? Wednesday কি হয় non-commercial? Wednesday not commercial, প্রথমে. We have heard Mr. Jishnu Chaudhary, Learned senior counsel, who concludes his submission in reply. Paragraph on the request made on behalf of the respondent. Respondent ki ektai? Respondent, comma, let this matter be listed again on Budbarer date daw, comma, retaining its position for Mr. Shoboshachi Chaudhary, Learned senior counsel, appearing for the respondent, to make his submission in rejoinder.
Just one sentence may I put in? My lord,
How long the sentence?
quite short, my lord. In fact, I'll break it up, my lord, to make it shorter. My lord, I pray for 51. If your lordship feels that I will not succeed, and if your lordship feels 46 is proper, my lord, I pray for 46. If your lordship feels that I'm going to lose, I may lose, my lord. 43, my lord, it can't get lower than 43. That's his evidence. Please give me 43 and finish it, my lord. I can't lose interest. He has to pay interest. So, my lord, I want here it to end here. These are my instructions.
Item number 2.
You're the appellant.
No, no, I'm the respondent.
That I am the appellant. Let my application under section 8 was dismissed. That on the ground that, my lord, the matters, my lord, concern, my lord, have my lord, aspects or elements of fraud for which it cannot be referred. Now, my lord, the law is now quite clear. My lord, when there's an arbitration agreement, well, even if the arbitration agreement comes under the scanner, if there's some allegations with regard to the arbitration agreement, well, even then, my lord, normally, in normal circumstances, that should be
Allegations of fraud are against you or against them?
against me. Well, lord, there is an agreement between the parties that is admitted. Well, lord, the parties were in a business relationship, well, lord, for quite a period of time.
You could have objected because you could have said, I want a public trial because there are allegations of fraud against me.
Yes, but my lord, here, my lord, now, my lord, the law is, as it stands, if there's an arbitration clause in an agreement, which is the subject matter of a litigation before a civil court, on an application made under section 8 before the filing of written statement, well, lord, the matter has to be referred to arbitration.
No discretion.
No discretion. Except, my lord, where, my lord, serious allegations of fraud, my lord, which will result in, my lord, conviction.
Or prima facie it is found there is no arbitration agreement.
Well,
that the section says.
That's right. That's right. Well, these are the only, my lord, two, my lord, criteria. Now, my lord, what had happened in this case is, my lord, that there is an agreement, my lord, there is no denying that fact. Well, lord, when disputes arise and we terminate the agreement, we, my lord, mention in our letter of termination that the agreement dated such and such will be terminated. Well, lord, then they say, give us a copy of the agreement. Well, lord, when we say, well, lord, thereafter, my lord, we proceed to terminate, the matter, my lord, takes a different turn. Well, lord, then we, my lord, file an application, my lord, under section 11 before the Bombay High Court. Well, lord, that application is not pursued because, my lord, we were advised that the right remedy is to file an application under section 8 in the pending suit, and, my lord, similarly, a reference order would be made. So, my lord, that application came to be filed. Now, my lord, the primary, my lord, objection that my learned friends say is that, my lord, there is, my lord, this agreement that is now being relied on is a forged and fabricated document. Why? Because it does not bear my signature. It bears their signature. They say that their signature in the document has been forged. Now, my lord, may I just point out, there is no mention as to which term in the agreement, my lord, is prejudicial or detrimental, my lord, to my learned friends' clients. I would appreciate that, my lord, today I forge a fabricated document or an agreement, my lord, to put in there, my lord, unusually favorable terms in my favor. But, my lord, there is no such allegation. So, the only assertion that is made is that, my lord, you have manufactured this agreement. Why? Because this contains an arbitration clause. And, my lord, for that, they take two things, two defenses. They said that, look, the arbitration clause that you had disclosed before the Bombay High Court, my lord, the agreement that you had disclosed in the Bombay High Court with the arbitration clause, my lord, contains stamp. My lord, the agreement that you've disclosed, my lord, in the High Court here does not contain stamp, or vice versa, my lord, I forget. So, my lord, there are two different agreements. And, my lord, that the Bombay High Court agreement has been stamped, my lord, on the 3rd of January, where the agreement is executed on 2nd January. Now, my lord, it is, my lord, a very common practice, my lord, in commercial, my lord, world to prepare agreements in duplicate triplicates. And also, my lord, that, my lord, you predate an agreement because the relationship comes into existence. But, my lord, the parties were in relationship. What would be unusual is, my lord, if suddenly, my lord, we find that there are terms providing for penal provisions, providing for, my lord, exit, my lord, without any cause, providing for, my lord, determination, and, my lord, consequences of interest or other liabilities. Well, lord, none of that is, my lord, complained of. So, the only issue that is raised is an issue with regard to the arbitration clause. Now, my lord, the question that would naturally arise, therefore, is, my lord, whether, my lord, this is one term which would be, my lord, incorporated in an agreement to fabricate an agreement or a relationship between the parties. And, my lord, here, my learned friends had thereafter, my lord, because my learned friends came and filed a suit before this honorable court. The agreement, my lord.
Are they saying there is no agreement at all between you and them?
Well, obviously, there is an agreement. Now, my lord, agreement under the, my lord, Arbitration Conciliation Act is something that can be borne out, my lord, even from correspondence. Of course, my lord, that is the arbitration agreement. My lord, there must be an agreement for there to be an arbitration agreement. And, my lord, Section 7 of the Arbitration Conciliation Act provides that, my lord, you may even decipher an agreement from correspondence exchange between the parties. And, my lord, they are saying that there is an agreement because their complaint is agreement has been wrongly terminated. for which they have suffered loss and damage, and the claim is for loss and damage.
Are they producing any such agreement?
No. They are talking of an agreement by conduct and by dealings and transactions. Now, the question is very simple. Here, is there anything of such nature and magnitude which would convince your lordship that it requires a public trial, without which the matter cannot be decided? Or is it something that in the ordinary course of things, the arbitrator himself can decide, by exercising his powers under section 16, or even by otherwise determining as to whether there exists an arbitration clause in a contract between the parties, because the contract is there, contract document is there. They do not assail any other term of the contract document. They do not say that any term of the contract document is prejudicial to our interest. The only allegation is that you have produced a document, you have manufactured a document. Why? What is the term which is prejudicial to interest? Not mentioned. I would presume that the term that is prejudicial is the arbitration clause. Now,
this document, the contract that you are relying upon, you say it has his signature.
Yes.
They are saying that signature is forged.
Yes. Now, today, the first question, and these are really first principles. When you commit an act of crime, there's a mens rea involved. You are trying to get an advantage out of a situation. When I fabricate a document, I want to take your house, or I want to take your property, or I want to take your business, or I want to get an unfavorable term in my favor, convert it. There is no such allegation. So, one wonders that what would be the purpose and object to be achieved by fabrication of the document. Now, the agreement, the party, Grief Scotland, has its office in Bombay, in Mumbai. The agreement says, of course, this clause is no longer valid, that Grief Scotland will appoint an arbitrator. The seat of arbitration will be Mumbai, and Mumbai courts will have jurisdiction. My learned friends come and file a suit in Calcutta invoking clause 12 of the latest patent. But so it is really then between Mumbai and Calcutta. That could be the only purpose. That would not be good enough reason to suggest that an entire agreement has been manufactured. Now, there is a subsequent agreement also between the parties, which does not concern this present contract, which is also disclosed. That agreement also bears their signature. That also contains a similar arbitration clause. So, here the question is whether there is such a manner of fraud or forgery which has come to notice, which would ultimately compel your lordships to say that no, this cannot be decided in arbitration, it must be decided in a trial. But a lot of judgments were cited in this regard. The learned judge has formed a particular view. May I take your lordships through the judgment?
The memo to the
paper file হয়ে গেছে হ্যাঁ জুনিয়রের সব কোথায় জুনিয়রের কোথায় সব জাজমেন্ট গুলো আছে তো What it extend to? Before termination. Before termination. Termination to 3rd July 2000. Before termination. Section 8 করলাম, তারপর section 11 করলাম, তারপর আবার section 8 করলাম। Yes, Mr. Shah. Well, dear Lordship has seen
Cognizance has been taken in
but
the
my lord,
criminal proceeding.
state. In criminal revision, state all records of the lower court transferred to the high court, so my lord, the lower court cannot proceed with the matter. That is where the matter rests.
Staying means it's in abeyance.
Yes, yes.
It has not been quashed.
No, of course not. that, my lord, it was challenged under 482 saying that, my lord, there is no element of, my lord, any criminal act. And, my lord, on that basis, High Court was pleased to entertain the matter and stay. Now, my lord, the question.
Sorry, just before you proceed, please address this. Page 15, internal page 15.
Yes, ma'am.
Paragraphs from A. Ayasami has been set out.
Right.
Paragraph 25 towards the middle.
Yes, ma'am.
On page 15.
Yes.
The sentence starting, it can be so done also in those cases where there are serious allegations of forgery, fabrication of documents in support of the plea of fraud, or where fraud is alleged against the arbitration provision itself, or is of such a nature that permeates the entire contract, including the agreement to arbitrate, meaning thereby in those cases where fraud goes to the validity of the contract itself, of the entire contract which contains the arbitration clause, or the validity of the arbitration clause. Keep this in mind.
The next sentence, reverse position thereof reverse position thereof would be that where there are simple allegations of fraud touching upon the internal affairs of the party inter se and it has no implication in the public domain, the arbitration clause need not be avoided and the parties can be relegated to arbitration. Now, my lord, here after Ayaswamy, my lord, the matter has received, my lord, further consideration for various courts. Now, my lord, please see, my lord, since your lordship is looking at Ayaswamy, please see, my lord, page 16. And then I should show you, lordship, how the, my lord, law has progressed.
Yes, I have seen in another judgment the Supreme Court says that this is archaic.
Before that, my lord, just before the last portion of, my lord, Ayaswamy, my lord, quoted at page, my lord, 16, the last, my lord, portion. Therefore, the inquiry of the court, while dealing with an application under Section 8 of the Act, should be on the aforesaid aspect, viz., whether the nature of dispute is such that it cannot be referred to arbitration, even if there is an arbitration agreement between the parties. Where the case of fraud is set up by one of the parties and on the basis that party wants to wriggle out of that arbitration agreement, a strict and meticulous inquiry into the allegations of fraud is needed. And only when the court is satisfied that the allegations are of serious and complicated nature, that it would be more appropriate for the court to deal with the subject matter rather than relegating the parties to arbitration, then alone such an application under Section 8 would be rejected. Because, my lord, the intention is to, my lord, refer the parties to arbitration. Now, my lord, the question is, when can the disputes be said to be non-arbitrable? Well, ultimately, if it touches upon, my lord, a public law element. Well, an act done against the state, because, my lord, when we are talking about a criminal act, it is always an act against the state, although the complainant may be a private party. Now, my lord, so far as this is concerned, the allegation is with regard to forgery of a document. Now, my lord, it is, my lord, every day.
Forgery of the document which you say contains the arbitration.
That's right. Now, it is every day that these allegations come, particularly in the hire purchase, my lord, matters. Your lordship will find, my lord, these allegations, my lord, fly off the cuff. Now, my lord, the question is, my lord, will the civil court, my lord, entertain all the applications? And simply because a person says that my agreement has been obtained by forgery, or, my lord, the document is a product of forgery, will it, my lord, then ultimately be said, she says, I file a police complaint. So, my lord, arbitration clause goes. Now, my lord, therefore, one has to, my lord, read it a little more constructively. The last part of Ayaswamy, my lord, makes it, my lord, clear. It says, my lord, then, my lord, there has to be, my lord, court is satisfied that the allegations of serious and complicated nature, it would be more appropriate for the court to deal with the subject matter rather than relegating the parties to arbitration and requires a meticulous, my lord, inquiry. Now, my lord, what the learned single judge has done with due respect is, please see, my lord, paragraph 40 of the judgment. In Ayaswamy, Rashid Raza Avital held that there are serious allegations of fraud. They are treated to be non-arbitrable. It is only the civil court that should decide the matters. In the present case also, the allegations of fraud against the defendant is serious in nature. Criminal case with respect of agreement is also pending against the defendant. Thus, it would not be proper for the court to refer disputes. Very cryptic, and only proceeds on saying that these are serious charges. Now, kindly look at the larger perspective of this. my lord, it would then be, my lord, very easy for a person to say my signature on a document has been obtained by forgery, or I am not a signatory to a document. And my lord, then my lord, make a criminal complaint, and then my lord, maybe persuade the, my lord, police authorities to, my lord, register an FIR, and then the matter goes out of arbitration. That is why, my lord, now kindly see, my lord, the judgments that follow IS1, which have been reproduced by the learned single judge in this judgment. Please see, my lord, Rashid Raza, my lord, which is at page 16. The principles of law laid down in this appeal make a distinction between serious allegations of forgery or fabrication in support of a plea of fraud as opposed to simple allegations. Two working tests laid down in paragraph 25 are: one, does the plea permeate the entire contract? And above all, the arbitration agreement of arbitration rendering it void. But it has to permeate the entire contract. And then, whether the allegations of fraud touch upon the internal affairs of the parties inter se, having no implication in public domain.
So does not an allegation of fraud saying that the entire document is fabricated or manufactured, does it not, the allegation,
yes,
does it not permeate the entire contract?
Well, it would permeate the entire contract only when it says that these contractual provisions were never agreed upon. And these contractual provisions have now been introduced to cause me prejudice or detriment.
No contractual provision was agreed
No,
upon.
but that is not the case. They agree that there is a contract.
Conduct of parties.
No, it's very well. They agree that there's a contract by the conduct of parties. Let us, my lord.
No written contract.
No written contract. But, my lord, the underlying theme of the contract is not disputed. The underlying contract, my lord, which is now reproduced in a written document, that is not disputed. My lord, I would appreciate that, my lord, you say that, but the contract is for selling property A. You have now manufactured a contract which says I will sell property B, which was never the agreement.
No.
That is not the case.
Do they anywhere admit that there is a written contract?
Well, no. What they say is there is a written contract in the form of a minutes of a meeting. Now, my lord, let me show your lordship what, my lord, the allegations are. Before, my lord, your lordship has seen the judgment. Please, my lord, look at some of the documents. Now, my lord, if your lordship will please have a look at, my lord, the agreement first. My lord, this is at page 18 of the paper book, volume 1.
This is the agreement you are relying upon in the present proceeding.
Yes, ma'am.
This is not the same agreement that you filed before the Bombay High Court.
No. Text, substance, everything same.
Same.
Only, my lord, one contains a stamp, one does not contain a stamp. Otherwise, there is no, my lord, change in the text or terms. Now, my lord, I am just trying to show your lordship what was the agreement between the parties and how, my lord, they have not said that this is not the agreement. My lord, please see, my lord, this is an agreement for supply of diesel engines for manufacturing generator sets. Now, my lord, page 19, please see relationship, principal to principal basis. Then there are terms of prices and delivery. Then next page, terms of payment. Then, my lord, trademark. Then, my lord, provision for exclusive use of Greaves engines. Obligation of original equipment, my lord, OEA, I don't know what it means. Indemnity, confidentiality, effective date, termination. And then finally, arbitration and jurisdiction. Well, the arbitration clause is clause 10 at page 24. Then please see, my lord, page 25. Well, it is signed on behalf of United Machinery, that is the respondent to the appeal. And, my lord, for Greaves Cotton also. So, my lord, both parties have signed this document.
This signature, they say, is not.
Right.
Made on is.
Now, my lord, kindly see, my lord, a document which they accept. This is at page 26. This is a subsequent meeting. Now, my lord, this is the minutes of a meeting which says, my lord, it is attended by both parties. A meeting was held at the premises of UMA, Kolkata, such and such, to bring about clarity to the business association between GCL and UMA. Well, the typed copy is on the next page. I don't think it's relevant. But, my lord, they accept that, my lord, there is an existing agreement and understanding. After that, my lord, your lordship will find that there's a dispute because, my lord, we want to expand our operations to the northeastern region. They want to be our sole and exclusive, my lord, business participants because they use our, my lord, engines to manufacture gensets. Now, my lord, when disputes arise, well, at that point of time, there's exchange of, my lord, letters and correspondence. My lord, there's a termination effected. But before the termination, well, they have already filed the civil suit. Now,
You will continue till recess, Mr. Shah?
yes, ma'am.
Then let us release your friends. That's why. 2 o'clock different bench.
The resolve, my lord, considerably weakens by 2 p.m. on Friday.
There is a 3:30.
Now, my lord, if your lordship looks at, my lord, the subsequent documents, now, my lord, the suit is filed. May I show you, lordship, the plaint? My lord, plaint is at page 104. Well, at page 105, well, your lordship will find paragraph 3. Well, it is in the above background of facts that in or around the year 2000, entered into an agreement with the plaintiff on the following terms. So, well, they accept that there is an agreement. They, of course, don't refer to any written document. And, well, the terms of the business are established. Well, these are not, well, in any manner different from the terms that have been set out. I should show you, lordship, why I say that. These are not, well, different from the terms in the written agreement that we have produced or relied on. Now, my lord, it is all, my lord, with regard to the facts of the case and why my learned friends are entitled to the claim for damages that they made. My lord, please now see, my lord, the cause of action in the suit, paragraph 10 at page 110. In or around year 2012, plaintiff came to know from reliable sources that the defendant has started effecting supply directly in Assam. Plaintiff has got direct evidence from the defendant approaching potential buyers of DG sets like such and such in the year 2013, but the fact remains that the defendant had in fact started direct business in northeastern India since 2012. Not only did the defendant start approaching buyers directly, but also engaged and promoted New Age Generators Private Limited, a private limited company to supply gensets to the plaintiff's dealers. And well, simultaneously, the defendant was planning to enter the market in eastern India. And then paragraph 12, on account of the aforesaid lapses on the part of the defendant, net sum of such and such, well, it became due and payable from the defendant to the plaintiff. And well, finally, at paragraph 14, they say, finally, the defendant stopped supplying diesel generator sets altogether to the plaintiff sometime around 1st July 2014. This they achieved by refusing to provide the plaintiff with their new engine prices as also relevant drawings. Then paragraph 15, as a consequence, plaintiff had to stop manufacture of diesel generator sets and its factory had to be closed down. Then they say that fixed overheads, they have suffered loss and damage. And on this account, they make a claim.
Are you the only one who manufactures this kind of diesel engine?
No. There are several. Well, diesel engines, are used in diesel generator sets. They manufacture the generating set, I supply the engines. Well, there are several. Of course, Greaves has some reputation in the field. And on that basis, the claim is, for, please see paragraph page 118.
Is Greaves Cotton a brother of Crompton Greaves?
It is a spin-off. I don't know, when there was a merger or demerger or change of name, but definitely, my lord, part of the old Crompton briefs. Well, then the suit is filed at page 118 after obtaining, my lord, praying for and obtaining leave under clause 12. There's a money decree. Then there's a direction to take back the dead stock. My lord, to have bank guarantees released and to, my lord, keep them indemnified from loss and damage. I don't know, my lord, this is the. Now, my lord, the suit, therefore, my lord, accepts that there is an agreement. Naturally, my lord, if the parties are in a relationship, in a commercial relationship, there has to be an agreement, whether written or oral. And well, they sometime in 2000 it started. Now, well, the written agreement that we are referring to is of 2007. Now, well, today, kindly appreciate one thing, that, my lord, the Section 8 application was filed, my lord, first in point of time, that has to be filed after the suit. My lord, before that, what happened is we proceeded to terminate the agreement. Now, my lord, the termination happened, my lord, on 3rd July 2015. The agreement was terminated after my learned friends had come to file the suit. So post-suit termination of the agreement took place. And my lord, that is termination is done by a letter of, my lord, 3rd July 2015, which your lordships will find at page 30. My lord, it is somewhat important. I'll just tell you, lordships, why.
Which page?
Page 30.
After this, we'd also like to have a look at the Section 8 application.
Yes, yes, of course. And the opposition, which is more important. Well, please straight away come to page 33.
July
2015. Well, the date is not very clear.
It is not there at all.
Not there. Well, that is the assertion of the date in the affidavit. So, my lord, I can venture to say with some degree of certainty that this is the date.
Yes.
Well, at page 33 is what is important. Well, last paragraph. Please further take note that I, on behalf of Greaves Cotton Limited, hereby terminate the agreement dated 2nd January 2007, as well as the minutes of the meeting dated 22nd October 2009, and further request you to pay the long outstanding dues of 1,04,53,103 within 7 days, such and such.
Any written response to this?
Yes, there's a response. Number two things kindly note. Here we mention the date of the agreement, 2nd January 2007. And my lord, we also say that we refer to the minutes of the meeting of 22nd October 2009. I've shown your lordship the minutes. My lord, that, my lord, clearly shows that there is an already ongoing relationship between the parties. And it is to give, my lord, some clarity to that relationship that this minutes is, my lord, executed. Then, my lord, the response to this letter your lordship will find at page 34. It is the reply. Now, my lord, two things. At paragraph 2, your lordships will find, well, it says, with reference to the statements contained in paragraph 3 of your letters under reference, it is denied that the business relations between Greaves and United Machinery began in 2006-7. On the contrary, in or around 2000, Greaves and United entered into an agreement inter alia on the following terms. Now, my lord, so far as the terms of the agreement are concerned, my lord, they have extracted, my lord, some terms of the relationship between the parties. Now, very importantly, they don't say at this point of time that, my lord, or, my lord, even not at this point of time, this is, my lord, what they set out is the agreement between the parties, how the parties will proceed. And then please see page 35, paragraph 3. You are accordingly called upon to provide a copy of the agreement dated 2nd January 2007 referred to in your letter under reference. And then, my lord, they go on to reiterate what is their plaint case. And they say that the matter is already sub judice before this honorable court. Well, to this, there is a response by Greaves, which is at page 38. Well, the terms of the agreement are not really very different from what is there in the written document. Page 41, we reproduce the arbitration clause in the agreement of 2007. We invoke the clause. This is really in the nature of a notice under section 21. And we nominate an arbitrator. Well,
yes.
To this letter of invocation, there is again a response, which you'll also find at page 42. They once again call upon us to provide a copy of the agreement. And then at paragraph 4, we hereby record our objection to invocation of the arbitration clause covering the alleged disputes as indicated in your letter and do not agree to the appointment of Mr. Such and Such as arbitrator. Call upon us to give an inspection of the agreement. Well, at the next page, your lordship will find an agreement that was entered into between the parties on 1st July 2010, which also contains a similar arbitration clause at page 49. Well, this is not really relevant because, this is not the agreement that govern the relationship of the parties. Now, the section 8 application, which is filed. What happened is, we filed a section 8 application. That was dismissed quite summarily. Then we filed a section 11 application before the Bombay High Court.
Section 8, that first section 8 was filed where?
In this court.
Here.
In the suit. Section 8 filed. Section 8 dismissed summarily. Then, on advice, we filed a section 11. That was kept pending. We were then advised to go to the Supreme Court and assail the order passed under section 8. Matter traveled to the Supreme Court. The Supreme Court said that no, you can't dispose of it so summarily, so matter is remanded back. When the matter is remanded back for fresh consideration of the section 8 application, the section 11 application is withdrawn. It is on that consideration on remand that this order is.
One question. If you had an agreement containing an arbitration clause, why would you apply for extension of time to file written statement?
There is an explanation in the section 8 application. Your lordship is right. That would be the first question. We have said that there was a shifting of the registered office. We could not locate the agreement then. The agreement came into our notice. Then we withdrew the application for extension of time to file written statement and filed this application instead. It is on remand that this matter came to be considered. Now, the section 8 application, if your lordships will have a look, that starts at page 1. It starts with that explanation that your lordships just now sought. Paragraph 3 at page 4.
Yes.
Application filed for extension of time. That is paragraph 3, then paragraph 4. They say that there was a change of the registered office and there was shifting, etc. That is paragraph 3. Since there was administrative change in the company, records were misplaced, there was delay in taking steps. And before that, at paragraph 2, registered office was shifted from Industry Manor in Appa Saheb Marathe Marg, Prabhadevi, Mumbai, to 3rd floor to Motilal Oswal Tower on 3rd floor of Gokhale and Shiny, Prabhadevi, Mumbai. So, there was shifting of office, and all this happened in 2015 itself, when the suit was also filed. Then paragraph 4, they say that it was later discovered that there is an agreement containing an arbitration clause. And then, the Section 8 application is filed. Well, at Section 8 application, well, it proceeds to say that there is an arbitration agreement between the parties, and well, hence the disputes should be referred to arbitration. Let paragraph 5 may be of some relevance, because well, here the statement is arbitration clause contained in the agreement of 2nd January subsequently continued in the minutes of the meeting of 22nd. So, it is accepted that 22nd October 2009 is a continuation of the agreement, and if the agreement between the parties contained an arbitration clause, that would naturally continue. But in all fairness, there is no reference to the arbitration clause in the minutes. Then it proceeds on the termination, etc. And ultimately the prayer to refer the disputes to arbitration. Now, what is more important is the affidavit in opposition filed to this application. Please see page 50. Now, by this time the agreement is disclosed in the application filed under Section 8. Now, here your lordship will kindly notice as to whether there is any allegation with regard to induction of any commercial term in the agreement, which is now sought to be relied on, which would operate to the prejudice of my learned friends' clients. That is why this document becomes relevant. Well, let me start with paragraph 7. At the very outset, I state that there is no arbitration agreement between the parties. The agreements disclosed by the defendant petitioner purportedly dated 2nd January 2007 and 1st July 2010 are forged and fabricated documents. The agreements dated 2nd January 2007 and 1st July 2010 do not contain signatures of the partners of the defendant / petitioner. May I pause here for a moment? I am the defendant. So the allegation is they don't contain my signatures, and that is why there is no agreement. The alleged agreements do not even contain the signature of the representatives of the defendant petitioner. Alleged agreements dated 2nd January 2007 and 1st July 2010 are instruments of fraud and should not be relied on. In the said circumstances, application should be dismissed with cause. At this juncture, your lordship finds that the allegation is that the signatures in the documents do not belong to the defendants. I am the defendant in the suit. Now, after that, they say the true and correct facts and circumstances are mentioned herein below. Although I would not, trouble your lordships ordinarily with these, averments, but all that I want your lordships to take note of is, there is not a single, paragraph here, or even a sentence, which would say that these agreements that have now been produced or generated, whether a product of forgery, fraud, or fabrication, they contain any such term, which was not originally agreed upon between the parties, which was not given effect to, or which did not govern their relationship, or any term which would now operate to the prejudice or detriment of the plaintiff. Now, here, if your lordship sees, paragraph 10.
The agreement that you disclosed with your Section 8,
yes,
that contained their signature.
Yes.
Do they say it's not their signature?
Well, I'm relying on what they have said in the opposition to the application. That is the document I have before me.
So beyond paragraph 7, that
there,
says
there is there are other paragraphs. May I, only before I proceed to the other paragraphs, show your lordship that in between the pages that are there, they make no mention of incorporation of any such term in the agreement disclosed with the Section 8 application, which would operate to their detriment, or which was not originally agreed upon, or which is introduced with the object of obtaining an unfavorable advantage. No such allegation. They only say that they have on our representations and assurances made certain investments, built up the business, and then we have stopped supplying generator sets to them. Whatever is the plaint case is really run here, and they say they have suffered loss and damage for which they have filed the suit. Now, again, we come back to what the agreement is at page 66. Or please start from the bottom of page 65. Paragraph 34. I'll not read the in-between paragraphs. Kindly take it from me that there is no allegation with regard to any incorporation of any term that was not originally agreed upon in the agreement of 2nd August 2007. The plaintiff respondent was thereafter was in receipt of a letter dated 3rd July 2015 issued by the defendant petitioner. In the said letter, the defendant petitioner relied upon a purported agreement dated 2nd January 2007. In terms of the said letter, dated 3rd July 2015, the defendant petitioner even terminated the purported agreement dated 2nd January 2007. Defendant petitioner, pursuant to a further letter dated 8th July 2008, invoked the alleged arbitration clause contained in the purported agreement dated 2nd January 2007. The plaintiff respondent did not admit the validity and or existence of the agreement dated 2nd January 2007. In fact, the plaintiff or respondent even called upon the defendant petitioner to produce the alleged agreement dated 2nd January 2007 by a letter dated 13th July 2015. Despite receipt of the aforementioned letter dated 13th July 2015, the original copy of the alleged agreement dated 2nd January 2007 has not been produced by the defendant or petitioner. The contents of the letter dated 3rd July 2015 and 8th July 2015 are untrue and incorrect and are denied and disputed. The agreements have been manufactured by the defendant petitioner with an intention, now my lord, please see, with an intention to defraud the plaintiff respondent of its legitimate dues. Well, there is no elaboration of this. The execution of the manufactured and forged agreements by the defendant petitioner is an afterthought and is done with an intention to bypass the claims of the plaintiff respondent. Well, Lord, kindly pause here for a moment. They do not say which clause, my lord, which covenant, and how, my lord, it has been done to, my lord, get an unfavorable, my lord, benefit. The plaintiff respondent thereafter on 1st October 2015 was in receipt of a copy of an application purportedly filed under Section 11 of the Arbitration and Conciliation Act 1996 before the Honorable High Court of Bombay. Well, this is the Section 11, my lord, where the disputes are sought to be referred. Then page 37, however, the defendant petitioner did not proceed with the said application filed under Section 11 and conciliation. In those circumstances, application was dismissed. Then paragraph 38. The plaintiff respondent, after perusing the application filed by the defendant petitioner under Section 11 of the Arbitration Conciliation Act, discovered that the defendant petitioner has relied upon two documents allegedly dated 2nd January 2007 and 1st July 2010. The defendant petitioner, on the basis of the alleged documents, applied for an appointment of an arbitrator. Upon discovering that the defendant petitioner had fraudulently prepared the documents dated 2nd January 2007 and 1st July 2010, plaintiff respondent initiated proceeding under Section 418, 420, 406, etc., read with Section 120B of the Penal Code before the learned Chief Metropolitan Magistrate. Now, my lord, again, I'll request your lordships to pause here for a moment. My lord, up to now, my lord, they have said that they discovered that the agreement was not signed on our behalf. Then, my lord, they say that the agreement contains unfavorable terms, but which does not is not pointed out as to what are the unfavorable terms in the agreement. And, my lord, then they say, upon discovering this, they file an application before the magistrate. Now, my lord, I would expect at this point of time to say as to, my lord, why it is stated to be forged. What is, my lord, the benefit that we are seeking to derive by introducing in the agreement such terms and conditions which, my lord, ultimately would amount to an act of, my lord, fraud?
Arbitration clause?
No, arbitration clause is, of course, one part of it. But, my lord, today, when the substantive contract, my lord, permeates the whole contract, my lord, that is what I am looking at. My lord, there is no such allegation. Permeates the whole contract, of which the arbitration clause is a part. I shall be showing your lordship the entire law on the subject because portions have been extracted.
Definitely, as you rightly said, Mr. Shah, there definitely has to be an agreement between the parties.
Yes.
If they are in a business relationship. But that may not be written. And if there is no written agreement, then there is no arbitration clause.
Now, my lord, there have been times without number where these allegations have surfaced before courts and the courts have said the referral court, well, lord, which in some cases will be Section 11 courts, in some cases Section 8
Very well,
courts.
we'll see those cases.
Yes.
You will not conclude today, no chance.
No, well,
5 minutes left.
Monday?
Yes. Yes.
It's all right.
Mr. Shaha, learned senior counsel appearing for the appellant, begins his submission but does not conclude. paragraph, list this matter once again, Monday date দাও তার আগে একটা লিখে দাও তো, this appeal is directed against a judgment and order dated March 21, 2024, whereby a learned judge of this court dismissed the appellant's application under sections 5 and 8 of the Arbitration and Conciliation Act, 1996. ঠিক আছে? The learned judge, in a nutshell, held that since there are serious allegations of fraud, the disputes between the parties should not be referred to arbitration. তারপরে Mr. Shaha.
But there is an interim order. Of course, it only says the suit not to be transferred to the undefended list.
It is limited in time.
It is till the end of this month.
Let it stand extended. The interim order that is in operation shall continue till the end of July, 2025, or until further order, whichever is earlier.
Right.
May I kindly to mention those two Jodhpur property those two matters which were released day before yesterday by your lordships to be taken up by this bench.
Lordship has, it has to be assigned. My advocate on record is taking step for formal assignment before this.
No. Oh.
Lordship order has said that matter has been formally.
Let the assignment
released.
come.
My advocate record yes, madam.
Yes,
Mr.
next
Dasgupta knows.
May be permitted to mention one appellate side matter.
This bench.
This bench, my lords, the judgment was reserved, was argued by Abhrojit Mitro just out of caution. It was reserved on the 6th of May. Now,
Yes.
since the bench has changed after that, so that the matter can be tagged along the next time the bench is constituted. It's just out.
Nothing is necessary. Yes.
Original side matter, item number 1.
I appear for the petitioner. Your lordship would remember that this is a matter of Deepak Dev. Your lordship have discharged him or dated 15th May, the last one.
আবার কি হলো তুই কিন্তু সেই দীপক দেবকে ডিসচার্জ করে দিলাম Tornendu Ghosh. Oh, Mr. Ghosh has some difficulty.
Yes, my lord. Your lordships will kindly not take me amiss. My lord, I don't think I'll be able to do justice to the matter. There are plenty of directions.
Parties, you write down a couple of names and give it to us.
Appoint anybody.
You are in a better position to suggest. Suggest.
The difficulty is, my lord, the other applicant is not appearing, and the other side is the officially good. But I'll, my lord, just
Not appearing, what can be done?
I'll just, my lord.
Your lordship will kindly pardon.
So what will we do? We want to consider and come back.
We'll give names, my lord.
Give names. Have you paid Mr. Dev's final remuneration? Oh, he's supposed to deduct it.
But we'll request the new person to, my lord, just have a check.
So lordship will not kindly, then passes it over. We'll
Yes,
consider
pass
it
over.
after. We'll give 3 names.
Pass over. Yes, take the consent of that person better. Otherwise, Mr. Sharkar, something like this, we did not take Mr. Ghosh's consent. Better not today. Whenever we sit, we may sit even earlier. You don't never know.
Whenever next.
Simply not today.
Item number 2 and 3.
Lordship, I appear for the respondent number 1, 2, and 7, led by
Yes. The first
number 1 to 7.
Where? This one? 2 and 3. Yes.
I was addressing you, lordship.
Lordship, let the appellant, Mr. Suman Kumar Dutt, is appearing online today. Lordship, he is not here in town. Let the appellant complete his submission. Thereafter, my lordship, if we wish to fix a date.
I am for the plaintiffs. Then, my lord, Mr. Ranjan Bachawat, my lord, who's appearing, my lord, to support the plaintiffs. He said he'd make his submissions, but I understand he's not well.
He's not in town, we are told.
He's not well. That's what I was. He's in town, but he's not well.
And
In
then,
some
my lord,
other matter, we were told he's in Bangalore or something.
no, that is Mr. Abhrojit Mitro.
No, Mr. Mitro we saw. All right, you will consume the rest of the day, Mr. Shah.
Well, I will take a little time, but my lord, I have already shown your lordships, my lord, most of the things. My lord, I don't know, my lord, whether I'll take the rest of
And we are not releasing. Let's just continue.
My lord, just a very brief recapitulation. My lord, will of 1800, my lord, provided sum of 2 lakhs of rupees for the establishment of one of the schools. There are 3 schools, one in Calcutta, in Lucknow, and in Lyon in France. Well, the Calcutta school was established, my lord, by this court, this honorable court. My lord, by this honorable court, I mean the Supreme Court, my lord, at that point of time. Now, my lord, that was done by a decree of 1832. Now, my lord, it is interesting because the decree of 1832 becomes material in one aspect. My lord, when, my lord, establishing the school and laying down the initial, my lord, modus of management of the school, my lord, the court said, my lord, the Supreme Court said that, my lord, this can, my lord, will be open to modification anytime. My lord, what the Supreme Court did was to, my lord, really act as, my lord, the settler in terms of the will, to give effect to the will of the founder of the school. Now, my lord, if your lordship has a look at this decree of, my lord, 1800, decree of 1832 once, which your lordships will find at page 163 of the stay application.
What was his name? Claude Martin.
Claude Martin. Claude Martin. He was a French national serving in the East India Army. Not legible.
The type copies also this. Go on that type copies.
Well, the original decree is not legible. Please see the type copy. And if your lordship will kindly have a look at, well, at page 179. Or may I request your lordships to look at at page 170, 176. This is where it first provided for the appointment of governors. If your lordship sees the middle of page 176, it provides for appropriation of the money, and provided always towards the last 5 lines of the page. The governors shall reserve in a hand and have on the first day on such and such invest monies. It provides for establishment of the school, provides for management of the school, funds for management of the school, and also for a board of governors, which will ultimately manage the school. That your lordship will find at page 179 towards the middle. It says, or may I read from the 4th line, and inasmuch as the court are of the opinion that it is not expedient to set forth in this decree the details, plans, and arrangement of the intended school, or to adopt the scheme approved by the said master in and by the said report, further than such parts thereof have been embodied in this decree, and that the intention of the said testator will be carried into execution and the institution rendered more useful and more conformable to the wants and circumstances of the objects of the charity by leaving such details to the governors. And it is hereby further decreed and declared that the subject to what has been hereinbefore specified and directed, the governors shall have full power and authority to select and appoint such masters, mistresses, teachers with such salaries as they may deem fit, to determine the number of boys and girls, etc., etc. So, all these powers are vested in the governors. And if your lordship sees page 180, whatever is required to be done by the decree by the governors shall and may be done and determined by the majority of them resident at the same time in or within 16 miles of Calcutta. This is the first decree. Just last page portion of page 180 becomes very important. Please see the last 5 lines before the witnessing portion. And this court doth further decree and declare that the Supreme Court shall at all times have full power of authority, either on motion by the Advocate General for the time being, or otherwise time to time, to make all such alterations for the establishment and management of the school as they may seem fit. So, my lord, this power of alteration is reserved. Now, my lord, this was followed, my lord, by a modification of the decree in 1944. My lord, pre-independence modification. So, my lord, the flavor and character of the old decree is, my lord, retained to a certain extent. Well, if your lordship will kindly have a look at the typed copy once again, that starts at page 180, 189, right?
One after another. One after another. One after another.
Huh?
One after another. One is the eligible copy, then the next is the typed
Oh, I'm sorry.
181.
My lord, it starts the copies at 181 and then immediately thereafter is, my lord, the typed copy. My lord, what is important is page 186. Please come to page 186. My lord, the second paragraph. Upon reading a petition of the Advocate General of Bengal and his affidavit, etc., etc., then my lord goes on to say, notwithstanding anything contained in the decree made in these suits and dated the 22nd date of October 1080 and 32, etc., then my lord says, His Excellency, the Viceroy and the Governor General of India shall be the visitor of La Martiniere School at Calcutta. Oh. Well, your lordships have that page. Page 181, yes. Page 186. Well, this is, my lord, how the board is reconstituted. Excellency, Viceroy and Governor General of India shall be the visitor of La Martiniere School, Calcutta. There shall be 12 ex officio governors of the said school in substitution for the governors appointed by any such decree or order in these suits as aforesaid. Such 12 governors being 1, His Excellency the Governor of Bengal, 2, the Honorable Chief Justice of Bengal, 3, the Most Reverend of Lord Bishop of Calcutta, 4, the Honorable Members of the Viceroy's Council in charge of education, 5, one of the members of the Executive Council of His Excellency the Governor of Bengal, to be nominated from time to time by His Excellency the Governor, one of the peonage judges of this court to be nominated from time to time by the Chief Justice, the Advocate General of Bengal, the General Officer in Command of the Presidency Brigade, the Director of Public Institution Bengal, the Chairman of the Corporation of Calcutta, Minister of St. Andrew's Church of Scotland in Calcutta duly nominated by the sessions of the said church, the President of the Bengal Chambers of Commerce. Provided that always no person for the time being holding or officiating in any of these offices who does not profess the Christian religion shall exercise or perform the powers or duties of ex officio governor.
Person or the just temporary.
Yes, good. Now,
Mr. Shaha,
yes.
The order proceeds on the basis that there is an old equity suit.
Yes.
That is pending, and it is only on that basis that it has been held that this suit is not maintainable. Whether that suit is pending or it has been struck off as has been submitted by you in the plain.
Well, we are not very sure because, my lord, when the matter was before, my lord, the other division bench of Justice Boshak, my lord, his lordship called for the records. And my lord, his lordship, my lord, was told or informed that, my lord, the suit had been, because, my lord, we had not mentioned, although we have mentioned about this suit in the plaint, my lord, we have not mentioned as to whether the suit survives or does not survive any longer.
Because that is the only ground which has weighed with the learned.
Yes, but, my lord, with the greatest respect, my lord, what is important is, my lord, when today, my lord, we apply for framing of a scheme, my lord, that can always be done by an independent suit. My lord, when we are talking about the provisions of the code which permit, my lord, such actions to be brought, my lord, the question is, my lord, today the school is established by an old equity suit or a decree passed in an old equity suit. My lord, that becomes really in the nature of a trust deed, because, my lord, the school is now a constructive trust over which the High Court exercises the parents' patri jurisdiction. My lord, the High Court, my lord, modifies the decree, says that, my lord, we modify the decree we we provide for administration of school with the rider that it can be modified. The modification comes in 1944. Well, it says also for the time being, these persons will be of Christian faith. The for the time being word is very clearly mentioned. Now, we had therefore gone on to say that none of these posts or persons exist, and even if they exist, they no longer profess the Christian faith. So, there is need to reconstitute the Board of Governors. At the end of the day, that is the long and short of the whole suit. It was a framing of a scheme of administration of the school. Now, at this juncture, the question that I asked to myself is how is it relevant as to whether the old equity suit is or is not pending? Because your lordship will find that thereafter, several other suits came to be filed also. For example, there was an occasion when there was a building to be constructed in a portion of the La Martiniere grounds. That brought the old boys to file a suit. That suit first resulted in some orders. Then, there was a compromise. I do not know what the compromise was. The building was allowed to be constructed. Money, of course, exchanged hands, and everything was forgotten. Like this, there was another occasion. The suit that the learned single judge notices was filed challenging the appointment of a principal of the school. That is also something that had no connection with the trust. Now we are asking for reconstitution.
That suit has nothing to do with the 1967 suit is the one which regarding the court said that is supposed to be used. That one also Basad said it is performed.
Mr. Shah, what my brother is saying is consider the learned single judge has not gone into the merits of your case.
Not at all.
If we say that it is irrelevant whether or not the old equity suit is pending, the matter needs to be addressed on merits.
Yes.
Send it back.
When we prefer this appeal against the decree, another set of 50,000 rupees is paid by way of court fees because it's now an appeal against the decree. The suit was dismissed. Now, I'll tell you, Lordship, what happens. Your Lordship will then have to set aside the decree, restore the suit, and direct GA8 to be heard again. What was GA8?
Correct.
We had filed an interlocutory application, got certain orders. These were challenged right up to the Supreme Court. When the matter came up before the division bench, then we contended that let a scheme be framed. The division bench was initially very inclined to frame a scheme, but then said, look at the limit of your interlocutory application. It was filed at the inception of the suit. And at that point of time, what you had said is that do not allow the dismissal of these additional governors or their replacement. So therefore, this scheme prayer that you now make before the division bench is beyond the scope of your original interlocutory application. So we will make our observations and send it back. You go and file an interlocutory application. So we file another application, GA8. It is in the course of disposing of the GA8 that the suit is disposed. Now, one very clear observation made by Justice Rai is the old equity suit. Old equity suit is still pending. Old equity suit is a suit in which the decree was passed and the decree was modified. That is still pending. The suit to which reference is made in the order of the learned single judge is another suit of 1967.
But it is referred to as the old equity suit only.
That is not correct. Please have a look at the impugned portion of the judgment and order. If your Lordship sees, paragraph 28. Paragraph 28, internal page 27 of the memo of the order. Please see, Mr. Murlidhar submits that the first equity suit number 2602 of 1967 was never decided and adjudicated finally. That suit was filed with regard to the dismissal of or the removal of a principal. This is not the original suit. Now, what happens? What is the submission? Submits that the first equity suit was never decided, adjudicated finally. He submits that even though there were only 3 of 12 Christian members who were functioning as ex officio board of governors of the court, held that the intention of the testator was to establish a school for the education of Christian boys and girls, then entrustment and management of the school to ex officio governors who profess Christian faith was quite proper and is recognized by the provisions of the Constitution. Pausing here for a moment, please see, this is the submission that was later recognized. Now, this order that is referred to is an interlocutory order. And my lord, if one looks at the decree of 1944, it says for the time being they will profess Christian faith. Pre-independence order. Now, my lord, that does not mean that, my lord, by any stretch of imagination, my lord, a new set of, my lord, plaintiffs cannot come and say that this is the object of the will, this is the instrument of trust, the decree of court, this is how it provides that the, my lord, trust estate or the school will be managed, and this is how it cannot be managed in the present circumstances. My lord, where is the difficulty? Why can't a new sit? Now, my lord, if your lordship sees what the learned, my lord, judge has held, my lord, please come to, my lord, the, my lord, portion well at page, where is that portion? Well, at paragraph 65. Now the issue, internal page 43. Now the issue of maintainability of the suit is taken into consideration. Immediately after grant of leave under section 92 of the Code of Civil Procedure, the defendant numbers 1 and 2 in an application being GS such and such prays for revocation of leave to be granted under section 92 of the code. This court by an order dated 12 July revoked the leave granted under section 92. In appeal preferred by the plaintiffs, appellate court by an order of 25th July 2019 set aside the order revoking the leave under section 92 on the ground that the question whether leave under 92 was granted properly or not shall be decided as a preliminary issue at the time of trial. Mr. Muralidhar referred to order 14, rule 2, sub-rule 2 of the Code of Civil Procedure and relied upon the judgment in Satyanath, which reads as follows. Where issues of both fact and law arise in the same suit and the court is of the opinion that the case or any part thereof may be disposed of on an issue, it may try that issue first if that relates to a jurisdiction of the court. Now, my lord, here this argument was made that, my lord, the issue of, my lord, revocation of leave to be decided, but there is already a division bench order which had travelled up to the Supreme Court, which says that no, the revocation is set aside and will be decided at the trial as a preliminary issue. Then, my lord, please see, after that, well, the question of revocation is discussed to an extent. Well, ultimately, please see paragraph 71.
তুমি ইন্টারলকিউটরিটা শোনো, ইন্টারলকিউটরি প্রোটেকশন যেটা চাইছে, সুট তো আমরা সত্যিই করি। যেটা
ECC. You need the CPC.
Page 189 में सूट का नंबर दिया। आप ये इस पर struck off from list. Now this is a division of is not anybody submission. Para 44 division which is going. We never make the submission as a struck.
Let's keep this open.
What were the prayers in the 1967 suit?
My lord, that is, my lord, at page 96 of, my lord, the impugned order.
Page?
Page 48, I'm sorry, page 48 of the impugned order. A scheme of management for the said school be settled, and in particular the provision of existing scheme relating to the disqualification of the governors on the ground of religion be declared void and deleted.
Basically about the management of the school.
Yes, but my lord, please see prayer B. This is what triggered the action. Defendants and or the defendant numbers 4 to 7 be removed from their alleged position as governors. Injunction be restraining as such and such from acting as governors, etc. Because, my lord, they had proceeded to, my lord, ultimately appoint a principal, if
No,
I
Mr.
remember
Shah,
correctly.
these different numbers 4 to 7 by now they may be in another world. We don't know.
Yes.
So these prayers have become infractuous.
Absolutely. And, my lord,
The plaintiff in this suit, this is not before us, naturally.
Well, kindly also notice one thing. Well, since your lordship is at this paragraph, this says the registrar original side has produced the original record of old equity suit number 2602 of 1967. This is not the old equity.
No, this is not.
Because, my lord, this suit is only the suit. My lord, at page 189, well, your lordship, this is only the suit number 260.
Wrongly described as old equity.
Number one. Number two, my lord, here, my lord, the division bench of Justice Boshak, my lord, called for the records. And my lord, the division bench satisfied itself that the suit had been struck off. We had not made any submissions. My lord, this is recorded in para 41 and 44 of the division bench order. Well, if your lordship will kindly see the division bench order once.
Mr. Ranjan Bachawat sir made the submission. That bench is found. That bench is found on that.
My lord, please see paragraph 41 of my lord, the division bench judgment at page 522. In respect of the affairs of the school, a suit being suit number 2602 of 1967 had been filed in this honorable court, where an interlocutory order dated February 1, 1968. I'm sorry. It is one judgment. Well, this is the division bench recording, page 522, paragraph 41. In respect of the affairs of the school, a suit being suit number 2602 of 1967 had been filed in this honorable court, where an interlocutory order dated February 168 was passed. This court had been informed that such suit was struck off from the register of suits in 1969. The judgment and order dated February 1, 1968, therefore has lost significance in view of such suit.
Possibly this was not pointed out to the learned single judge.
No, well, para 54, well, paragraph 53 and 54 of my lord, the impugned judgment and order. Mr. Bachawat, my lord, 53 and 54, Mr. Bachawat submits that in the year 1967, the decision of governors to appoint a new principal was challenged on the ground that the ex officio governors did not have the right to appoint additional governors, and as such, the decision taken by the board comprising of 3 ex officio and 4 additional governors was bad. He submits that the court was prima facie of the prima facie view that the restriction on the ex officio governors being Christian did not apply to additional governors, and the appointment of additional governors was valid. He submits that the question of whether restriction on the ex officio governors being exclusively Christian was valid or not, or required to be changed, will be decided by this court at the final hearing of the suit. Then, my lord, please see paragraph 54. Mr. Bachawat submits that in this honorable division bench, by an order dated 13 July 2023, held that the suit number 2602 of 1967, in which the interlocutory order dated 1st February 1968 was passed, has been struck off from the register of the suit in the year 1969. Therefore, the judgment and order dated 1st February 1968 lost significance, as the suit in which the order was passed no longer remains.
So, having noticed this, how could the learned judge have said that?
Well, I think, well, it was a bit of an oversight, because, well, here, well, the online case status of this, my lord, suits, the 67 suit, also shows, well, decision date 31st December 67, case disposed.
Case disposed.
And 31st December 67 was apparently a holiday.
Huh?
Well, what used to happen apparently, my lord, when, my lord, these old records, my lord, suits used to come up, and, my lord, records could not be found, my lord, the learned judges would at times sit on, my lord, vacation days and dispose this off. That is what, at least what the division bench pointed out to us. My lord, because this was also asked, then how could it be disposed of on a vacation day? Well, I'll tell you, Lordship, my lord, the difficulty. My lord, the only issue is, my lord, whether the school can be continued to be run in the fashion it is being run today by 2 out of 12.
No, correct, Mr. Shah. Your suit has been dismissed on a ground which on the face of it appears to be not tenable.
Yes.
So we, in a 2-paragraph order, we set aside the decree, send it back.
Your lordships may, but your lordships may also, my lord, take up the matter and, my lord, deliberate on
Which
this.
precisely we don't want to at this time. Our hands are full. We appreciate this is the only original side appeal court.
My lord, I realize that, but my lord, the issue is really so simple that, my lord, I don't
Exactly. That is why the learned judge can simply dispose it off, going into the merits of the case.
Well, this matter was argued for 1.5 years. And, my lord,
Not before us.
No. No, my lord, your lordships, my lord, take it up and finish it at one go. That is, my lord, the best part of it.
It'll be a loss of forum to both sides also. Because obviously on a ground which is factually incorrect, it has been disposed of.
My lord, may I, my lord?
My lord, before my learned friends say, my lord, in this matter, my lord, there was an interim order that was operating.
No,
my lord, order was that, my lord, there will be no, my lord, acts done, my lord, which would be except apart from the normal day-to-day function of school. Now, this is the language.
Mr. Shah, if we set aside the decree, that will stand restored.
Kindly make that clear, because, my lord, what they have done is, my lord, as soon as the, my lord, suit got dismissed, they have, my lord, proceeded to appoint 4 additional directors of the governors of their choice. I mean, again, my lord, everything is back to, my lord, glory days.
And we will request the learned single judge also to give some priority to this matter. Yes, what do you want to say?
My lord, so far as reference to this is concerned, my lord, which is, my lord, now troubling your lordship, that, my lord, it's probably misplaced. I'll tell your lordship in a minute. My lord, what had happened is this, my lord. At that juncture, when the suit was filed, my lord, in 1965, the board, my lord, did not have the requisite number of governors, and that was an issue before the court. Now, my lord, I had relied upon this judgment to show that at that juncture, the court had taken into consideration this fact and had said that no, this is not a ground for changing or the scheme, but the 4 additional governors can operate and co-opt as per the rules, and therefore. Now, my lord, the question arose that this was an interim order. The court inquired at that stage, if this is an interim order, what is the finality of that? So at that point in time, my lord, records were sought for, and it was given to understand that the suit was ultimately dismissed because the plaintiffs did not pursue the suit. But it was also our argument vis-a-vis this, that so far as this suit is concerned, this suit does not contemplate any of the grounds or cause of action for the purpose of amending the scheme. And there is an old equity suit pending before this honorable court where the scheme can be altered or touched. Now, my lord, this argument was advanced before the learned single judge. I am told, my lord, subject to correction, my lord, I am told that the learned single judge probably has gone into the records and have found that the suit is still pending. But the pendency of the suit, my lord, may not be of relevance, this suit, the 67 suit, except for the interim order that I was relying on to show that in the previously, my lord, in this given situation,
Shah, we are going to see it very often now, so don't worry. We are calling for a report from the registry.
My lord.
Well, may I just, my lord, make this inquiry, my lord? I mean, even if your lordship find that the suit is alive or suit is not alive, my lord, honestly speaking, my lord, the question that will engage your lordships is, my lord, whether this suit could have been filed.
You're right, but factually we want to know. Because the division bench records, it has been struck off. The learned single judge notices that and then says, no, it is pending. On what basis? On what basis? Issue. In the judgment and order impugned, at paragraphs 53 and 54 of the judgment.
May I also pray? Well, may I also pray that the records of old equity should be
Yes,
also brought
yes.
before this court?
Which old equities?
That would, my lord, help the court, my lord, to appreciate the issue before your lordships.
53, 54, huh? Comma, it is stated as follows. এই দেখো মেমোর সঙ্গে জাজমেন্টটা আছে, ইম্পিউন জাজমেন্টটা, তার ইন্টারনাল পেজ 38 paragraph 53, 54 paragraph. However, at paragraph 77 of the judgment, comma, the learned single judge records the following. It was 77, page 49, paragraph. Therefore, comma, there appears to be tremendous confusion as to whether or not suit number 2602 of 1967, which has somewhat incorrectly been described as an old equity suit, comma, is pending in this court. Paragraph. The registrar original site. Registrar, comma, original site is requested to submit a report to us by the next date in the above regard. Stop. If now the records of suit number 2602 of 1967 should also be produced. Stop. The records of old equity suit.
Lordship, this is the details of the old equity.
देखिए
That's a pending perpetual suit.
It has no number.
It's
26.
26 of 1888.
It is read in
Being CS 26 of 1888. 18 CS 26. Records of the old equity suit. Being CS 26 of 1888, which was registered on January 1, 1888. Department it's registered on, should also be produced before us. Next Friday? List the paragraph, list the matter. Next Friday. Next Friday.
Well, next Friday, my lord, I will not be available. Kindly keep it the
Friday week. Friday week তারিখটা দিয়ে দাও তুমি শোনো এদিকে
division bench. They have taken advantage of the strength of passive
There's one request. If not next Friday, it may come up, if possible, on 4th of July, next to next Friday. I mean, if it is convenient to your lordships.
That is 4th July, my lord, I will again be in Delhi. My lord, let us start, my lord, because my lord, we are, my lord, going to make submissions.
So you said next Friday you are not here.
Next Friday, my lord, would be the 27th, I think.
You are not here, you said.
I'm not there on 27th.
4th July?
4th July.
Well, your lordship will kindly keep it, my lord. Let it be on the 27th itself. My lord.
So if you are not there, what?
No, my lord, Mr. Bachapat is there, my lord. This issue, my lord, anyone on
next week, 27 July করে দাও
27
June, 27 June. কে কোথা থেকে কথা বলছে কিছু
Well, only one thing, my lord, the order, my lord, the division bench, my lord, that needs to be continued. My lord, the suit was, my lord, dismissed on, my lord, the technical ground. The order of the division bench was that the board of governors, my lord, present board of governors, which is one or at best two, my lord, they will only perform day-to-day, my lord, business. This is the language. It would be appropriate to direct the board of governors of the two schools will not take any decisions regarding management of the schools till the disposal of the interlocutor application.
Mr. Shah, next Friday, let us ascertain this status once. Remind us, your juniors will be here.
Very well.
We are grateful, my lords. Much obliged.
Grateful.
Item number 428.
Transfer. इधर भी फिर बड़ी वो पेंडिंग था अरे भाई
বইটা দাও এর বই কোম্পানি দাও যাই May it please your lordship. My lord, I would request your lordship first come to straight to the impugned order, page 215 of volume 2. Page 215, volume 2. I shall quickly go through it, this judgment. This application has been filed by secured creditor, Edelweiss Asset Reconstruction Company Limited of JSOP and Company Limited, the company in liquidation, seeking transfer of CP number so-and-so, along with all connected applications.
1 second, Mr. Mitra. তাও নাকি volume 2 বলছেন, শোনো?
Volume 2, page 215.
That's the impugned order?
That's the impugned order.
Oh. Internal page?
215 of volume 2.
The internal page of the order.
Oh, no. This is the order I'm placing from the very first.
From the beginning.
So that your lordship knows exactly what
yes,
what had transpired in the trial court. This application has been filed by a secured creditor, Edelweiss Asset Reconstruction Company Limited of JSOP Company Limited, the company in liquidation, along with connected applications to National Company Law Tribunal, Calcutta. The application has been filed under the 5th proviso of the newly amended section 434(1)(c) of the Companies Act. The section in its new avatar contemplates a party applying to the court to seek transfer of proceedings relating to winding up of a company to NCLT. Then another submission has been recorded. Your lordship will please to come to the middle of the paragraph 2. By an order dated 18th May 2017, the contributory was permitted to take physical possession of the assets of the company in liquidation, and the official liquidator was directed to be in symbolic possession. This mallet contributory is my client. The order was also provided that the expenses incurred for providing security guards in respect of the assets of the company in liquidation shall be borne by the contributory. By an order dated 17th August 2017, The contributory was also directed to bring a scheme for payment of the dues of the creditors of the company in liquidation. However, admittedly, till date, no scheme has been framed. Significantly, the applicant has also filed an application being CA number 172 of 2019, seeking appropriate directions for the official liquidator to hand over possession of the mortgage properties of the company in liquidation to the applicant. Then the contention has been recorded with regard to the fifth proviso. I shall take your lordship into those provisions. I am not troubling your lordship. The decisions have been cited. Then, my lord, kindly see our contention in paragraph 4. On behalf of one of the contributories, namely Indo-Wagon Engineering Limited, it is submitted that the petitioner is not a party to the winding up proceedings and hence is not entitled to seek transfer of the proceedings to NCLT. This is one of the points. It is further alleged that the absence of any application pending in the insolvency court before NCLT, there is no question of transferring these proceedings to NCLT. It is further submitted that there is no power vested in the NCLT to consider an application for framing of a scheme for repayment of the creditors of the company in liquidation. It is also submitted that irreversible steps have taken place in the form of payments having been made to security agencies and the pendency of an application under section 466 of the Act filed by the contributory and pending applications for framing of a scheme in respect of the company in liquidation. All these steps have been irreversible in nature and would severely prejudice the rights of the contributory. Reliance has been placed on the judgment. I shall place this judgment afterwards. Manchandra's case, to contend that the peculiar facts of the case would make a world of difference between the conclusions in two cases. Thus, the decision reported in Ishpat action and Navin Chandra are distinguishable pursuant to the direction, etc. And then, my lord, the amendment dated. The amendments have been referred to. I'm not troubling your lordship. Paragraph from action in Ishpat has been quoted. Paragraph 25. I shall, my lord, come to it, my lord, afterwards. Then, my lord, page 220. The internal page 6. Significantly, in the facts of the aforesaid decision, the concurrent finding of the company judge and the division bench was that, despite the fact that in the liquidation proceedings, the official liquidator had taken possession and control of the registered office and the factory premises, records and books, no irreversible steps towards winding up of the company had otherwise taken place. This was the finding of the court. The ratio in action Ishpat and power has subsequently been followed in Navin Chandra in 2021 4th Supreme Court cases. Then, my lord, Maheshwari Ishpat has been quoted, to which, my lord, I shall refer, my lord, in course of my submission. And, my lord, here, kindly, this paragraph perhaps will be of some importance when I make my submission. May I place this paragraph, my lord, this quotation from Maheshwari. Quote, ordinarily, there is a strong presumption that civil courts have jurisdiction to decide all questions of civil nature. The exclusion of jurisdiction of civil courts must either be explicitly expressed or clearly implied. In my view, the section does not contemplate proceedings being automatically transferred to the tribunal. There is an element of discretion which the company court retains in respect of pending proceedings, whether to exercise the power to transfer or not, depending on the facts and circumstances of each case. The only test as laid down by the Supreme Court is whether any irreversible situation has arisen, warranting the court to stay its hands and not transfer the proceedings to NCLT. However, the clear legislative intent is to oust the jurisdiction of the court and transfer all proceedings to the tribunal, except in limited cases, with the ultimate object of resuscitating the corporate debtor who are in the red, and in some cases to prevent parallel proceedings. In fact, my lord, my submission will be this, that the scheme which I am seeking to frame, which I could not frame by reason of these proceedings, is only to, my lord, revive the company. If the purpose of IBC is to revive the company and not to put the company into liquidation, then, my lord, precisely that is what is sought to be done before the company court by by my client in the application. Then, my lord, para 8. This is the judgment really starts from here. In the newly introduced insolvency regime, and after the aforesaid amendments to the Act, there is a radical change in the approach whilst dealing with the companies in liquidation. It is true that there is no automatic transfer of all proceedings pending for winding up of a company to NCLT. In fact, there is an element of discretion which the company court retains in respect of the pending winding up proceedings, even post-amendment. However, such discretion has to be exercised in the facts and circumstances of each case. Then para 9, the sole test laid down in the decision of Action Ishpat as followed in Navin Chandra is whether an irreversible situation has arisen warranting the court to stay its hands and not transfer the proceedings to NCLT. In my view, there are no facts whatsoever which justify the conclusion of an irreversible situation having arisen in the facts of the case. I am questioning this sentence. The company was directed to be wound up on 6th March 2017. Thereafter, one of the contributories, namely Indo-Wagon Engineering Limited, had obtained diverse orders from the court, whereby they continued to be in possession of the assets of the company in liquidation. Admittedly, till date, there is no scheme for repayment of the outstanding dues of the creditors, which has been framed. My lord, this perhaps, my lord, I will have to question this particular sentence also in course of my submission. No other steps have taken place by the official liquidator in aid of the company, of the winding up of the company. The aggregate dues of the applicant are in excess of rupees 400 crores. Notwithstanding orders of this court, the security agencies have also not been paid by the contributory. The official liquidator is not in possession of any of the assets of the company in liquidation, far less having made any attempt to sell them. The stalemate or impasse which has been created by the contributories and the inaction of the official liquidator only strengthens the case of the applicant to seek transfer of the proceedings to NCLT on the ground that no irreversible situation has arisen to justify this court to retain the jurisdiction. Section 434(1)(c) provides any party to any proceeding relating to winding up of the company may file application for transfer to NCLT. A proceeding for winding up is a proceeding in rem, which inures to the benefit of all creditors. Such a proceeding may be initiated by one or more creditors, but is treated as a joint petition. It is well settled that a secured creditor may choose to stand outside the winding up proceedings, kindly note this, and enforce its security divorce the winding up proceedings. Thus, and then my lord, quotation is quoted from Mama's Company Law. Thus, the fact that the petitioner has chosen to stand outside the winding up proceeding does not mean that the petitioner is not a party within the meaning of section 434(1)(c) of the Act or is disentitled from making this application. I am questioning this also. Then, my lord, para 11. I also do not find any merit in the objection raised by the contributory that a petition under section 7 and section 9 of the Insolvency and Bankruptcy Code to 2016 should be pending before NCLT prior to directing transfer of the winding up proceedings to NCLT. Neither is the legislative intent nor is this precondition borne out from the language of the newly amended section. Accordingly, I do not find any merit in this submission and the same is rejected. I also do not find any force in the submission that a scheme for repayment of the creditors of the company in liquidation cannot be considered by NCLT. Section 230, subsection 1 of Companies Act contemplates that a scheme of compromise or arrangement may be submitted under the provisions of the code. Moreover, Rule 2B of the IBBI Liquidation Process Regulation 2016, read with Section 230 of the Companies Act 2013, now govern the process for submitting a scheme of compromise or arrangement. Under Section 20, what has been ignored perhaps, my lord, is that this situation will not arise once, my lord, the matter goes before the NCLT, or rather, my lord, before the under the IB code. My lord, then a completely different proceedings will start with, my lord, the committee of creditors coming into the picture, my lord, the resolution professional being appointed for the purpose of, my lord, dealing with the company. It's a complete, my lord, this concept, this aspect of the matter has been ignored by the court. The court proceeded on the basis as if, my lord, just as, my lord, a scheme application is, my lord, considered by a court of law. NCLT will do that. No, because before that, all these procedures will take place. I shall come to that, my lord, how the things will. But I must frankly confess, your lordship, to your lordship, my lord, that insofar as I am concerned, I could not find, subject to what my learned friend says, I could not find a similar case having been dealt with from the reported decisions. This will be a unique case from that point of view. A case, my lord, in which sufficient proceedings have been taken recourse to. The courts have passed various orders. In pursuance of the orders, the creditors have been paid off. The substantial amount of dues of the workers have been liquidated. The person who is seeking to frame the scheme has taken possession of the properties. But I will submit to your lordship, an irreversible situation has arisen when your lordship looks into the totality of facts in this particular case. And to that, in that one, this is, my lord, what has been, I very respectfully submit, had been ignored by the learned trial judge. Irreversibility does not necessarily mean sale of the properties only. Situation can be irreversible in very many ways. Now, I ask this question to myself, and I shall elucidate this submission of mine before your lordship. Today, I have spent, I shall show to your lordship, say a few crores of rupees by paying off the dues of the creditors, by paying off the dues of the workers, by paying, my lord, the security guards. Who is going to, my lord, reimburse this? I've got to file a suit, or I don't know what to do with this. My lord, what is the irreversibility? We'll have to consider that in the facts and circumstances of the case. The cases which have been cited, the Supreme Court had considered where, my lord, the properties have been sold. So that was one aspect of the irreversibility. But there may be various aspects of irreversibility. We cannot shut our eyes to it. As I submit to your lordship, crores of rupees have been paid off. Who is going to pay me out? Then, my lord, under section 29A of the Insolvency and Bankruptcy Code, the promoters are disqualified from framing a scheme of the company. Accordingly, this submission on behalf of the contributory is also rejected. I also do not find any merit in the submission that the fact that some monies have been paid, my lord, kindly note, that some monies have been paid by the contributory would create an irreversible situation which justifies these proceedings not being transferred to NCLT. My lord, not has been dropped out. None of these grounds make it impossible to set the clock back, compelling the company court to proceed with the winding up company instead of transferring the proceedings to NCLT. My lord, this is what. None of these grounds make it impossible to set the clock back by compelling the company court to proceed. My lord, I will ask this question, that what is this, my lord? Who is going to, how the clock is going to be set back by paying the money? Who is going to pay me back my money that I have paid? Today, you completely get rid of me from the picture. I go out of the picture altogether. What happens to my money? I file a suit. This, my lord, and my lord, suit against whom? That is also another question. I have paid off I have liquidated the debts to a large extent. I shall show to your lordship, my lord, in course of my submission. This issue has not been really gone in. This particular issue, my lord, has not been gone into by any of the decisions that I have seen. Everybody is talking of irreversibility and with reference to sale of property. If the property has not been sold, then no irreversible situation. No, I said that is not the situation. But the workers have been paid 72 lakhs. Their dues have been liquidated. What will happen to that money? What will happen to the workers who have retained for the purpose of starting the company all over again? Your Lordship kindly says, my Lord, kindly come to page 223, internal page 9. All such issues can always be decided by NCLT during the course of winding up. How can it be decided, my Lord? I would like to hear, my Lord, the suggestion of my learned friend, how NCLT will decide these issues ultimately. My Lord, they are the adjudicating authority, and my Lord, I shall come to it after.
Whose application was it, Mr. Ratnanku Banerjee's? He is Edelweiss.
Yes, Edelweiss.
He is Edelweiss.
Secured creditor who had expressly gone out of the winding up proceedings, stating, my Lord, his statement has been recorded that I do not want to proceed with the winding up. And my Lord, I want to stay out of it. And if they proceeded before, my Lord, the Debt Recovery Tribunal, claiming 434 crores of rupees against my client. And that is pending and that adjudication is going on.
They got a certificate, sir.
And they got a certificate. On the basis of that, they got a certificate.
Executed.
Not yet executed.
Pending, and now they filed a section 7 for the IBC after this.
And now, my Lord, I am told, my Lord, the section 7 application has been made by them now. Then, my Lord, the next sentence, hence there is no impossible situation arisen which justifies the court retaining this winding up proceedings. It is to be remembered that the jurisdiction to change, a jurisdictional change brought about in the amendment of section 434(1)(c) makes it clear that it is now obligatory for the court, in the absence of any irreversible or exceptional circumstances, to transfer the proceedings to the NCLT. This is the clear legislative intent. In fact, to continue with the winding up proceedings in the absence of an irreversible situation would, in my view, tantamount to committing jurisdictional error. The decision relied on by the contributory in Amrit Malchanda's case is distinguishable and is inapplicable in the facts of this case. In view of the aforesaid, I direct the company petition being CP number so and all applications filed therein stand transferred forthwith to the National Company Law Tribunal, Kolkata. So this is what has happened. Now, before I go into, my Lord, the legal aspect of the matter, my Lord, may I draw your Lordship, my Lord, to page 177 of this volume, volume 2. Just to show to your Lordship what payment has been made in the same volume at page 177. The company petition numbers, my Lord, are mentioned in this serially from 1 to 6. My Lord, this is a chart with regard to the payments made to the in different company petition to the different creditors. In CP number 387 of 2014, Ravi Shankar Singh had been paid. The amount date of payment is 8/5/2017. Amount paid is rupees 10 lakhs. Settled in full.
This is the matter in which the admission order was made.
This is the first one, is the application in which, my Lord, the admission order was made. So, my Lord, he has been paid in full. Then CP number 809 of 2015, Fairtex International, the payments have been made on different dates, 4 lakhs, 4 lakhs, 15 lakhs, 25,000. All told, my Lord, 23 lakhs, 25,000 has been paid, nothing, no balance. And, my Lord, CP has been withdrawn. Then number 3 is CP 300 to 2015, Alak Kumar. My Lord, payment made, total payment made is 60 lakh 50,000. And this has been settled in full. Then CP number 440 of 2015, Sanjeev Grover, dated 18th May 2017, 4 lakhs of rupees was due. 82,280 has been paid out of the principal sum of rupees 3,82,000 as recorded in the High Court order. An amount of rupees 8 lakhs has already been paid. Out of the balance, 75% is proposed to be paid in 2 months. Then, my lord, this is with regard to 4 lakhs and 4 lakhs, two amounts of Sanjeev Grover. Then, my lord, the fifth item is official liquidity High Court Calcutta. I suppose security. Security and other costs. This is official liquidator, 20,000, 2,84,000, 3,75,000, and 14,60,000, 8,070. Now, this is another amount. The balance has, I do not know, there is no balance. Then workers' gratuity. The amount paid, the total amount is 7,96,208, proposes to pay 75,000 on the principal of 24 equal monthly installment. Now, this is the position with regard to this. Now, on the basis of this, my lord, the matter was being heard in the court. Well, two orders I will request your lordship to look into. One is the trial court order, in which, my lord, it has been recorded, page 100. It's the first volume. First volume, page 100.
Volume 2.
This single bench order, volume 1. এখানে নেই, এই দেখুন, এইটাই volume 1 সামনে। এই তো volume 1।
Two তো বাবা। ওইটা কি? ওইটা? ও হ্যাঁ, আমার 1টা কোথায়? Yes.
This is 17th August 2017
Yes.
of the trial court, Mrs. Mukherjee's order. Today, Mr. Adhyab, for the secured creditor, submits that her client wants to stay outside the winding up proceedings and pursue their claim otherwise in accordance with law. Hence, it has been taken that the secured creditor, Messrs. Edelweiss Asset Reconstruction Company Limited, has no objection to the setting aside of the winding up order. And they are the persons who have made the application for transfer. So this is your lordship. I'm not troubling your lordship with any other part of the order. Kindly now come take the division bench order at page 178 in volume 2. The appeal arises out of an interim order passed on December 13, 2018 on the appellant's prayer for release of funds for the appellant, having engaged security guards to protect the assets of the erstwhile manufacturing facilities of Jessop and Company Limited, now in liquidation. Then, my lord, I am not troubling your lordship with the grievance of the appellant. Then, my lord, next paragraph at page 179. The order impugned was passed on a petition under section 466 of the Companies Act 1956 by the contributors. That's my application. The petition is yet to be disposed of. Pursuant to the directions issued by this appellate court, the secured creditor of the company in liquidation have been served. According to the official liquidator, the only two secured creditors of the company in liquidation are Edelweiss Asset Reconstruction Company Limited and ASREC India Limited. Both Edelweiss Asset Reconstruction and ASREC are represented both set of secured creditors seek to stand outside the liquidation and are pursuing their claims before the appropriate debt recovery tribunal. So, my lord, keeping this in mind, my lord, I will request your lordship to look into the Companies Act section. Now, my lord, I am going to make myself. Sorry. Then, my lord, Junior rightly points out at page 180, in continuation of it. Yes, I forgot to place it for lordship. The penultimate paragraph on that page.
Notwithstanding.
At page 180. Notwithstanding the two secured creditors of the company liquidation not submitting to the liquidation proceedings, it is apparent that the assets protected by the official liquidator may ultimately be taken up by the secured creditors as part of their security. Thus, the protection of the assets is in the interest of the secured creditors, and the secured creditors must bear or at least share the expenses therefore, which they did not. So, my lord, this is the position. Now, keeping this in mind, your lordship will be pleased to look into section 434 of the Companies Act 2013. This section 434 has been brought into the statute book by way of amendment, and this was in 2016. Transfer of certain pending proceedings. If your lordship has got the new well, these two acts, my lord, this Companies Act and, my lord, IBC. So it goes on, my lord, being amended so frequently that we, my lord, on this side of the profession, my lord, we are becoming what should I say, indigent by reason of spending money on these two books. And these are both, my lord, voluminous. Lordship will kindly take section 434. Transfer of certain pending proceedings. On such date as may be notified to the central government in this behalf, all matters, proceedings, or cases pending before the Board of Company Law Administration, etc., constituted under subsection 1 of section 210E of the Companies Act, immediately before such date shall stand transferred to the tribunal. And then, my lord, kindly come to C. That is the one that really concerns us. All proceedings under the Companies Act 1956, including proceedings relating to arbitration, compromise, arrangements, and reconstruction, and winding up. Kindly see, winding up is one such. Of the companies pending immediately before such date before any district court, the High Court, shall stand transferred to the tribunal, and the tribunal may proceed to deal with such proceedings from the stage before the transfer. Now, pausing here for a moment, without looking into the provisos, it appears from the language of this section that it is a matter of automatic transfer. I mean, without anything more, it will be transferred. But, my lord, the provisos will have to be read along with this. Here, if your lordship kindly comes to, first I shall take your lordship through each of the provisos. Kindly come to proviso 5, the last proviso. I hope, my lord, in your lordship's copy, this amendment has been incorporated. This is, my lord, 2018 amendment. It is provided further that any party or parties to any proceedings relating to winding up of the companies pending before the court immediately before the commencement of the insolvency and bankruptcy court may file an application for transfer of such proceedings, and the court may, by order, transfer such proceedings to the tribunal, and the proceedings so transferred shall be dealt with by the tribunal as an application for initiation of corporate insolvency resolution process. From section 7 onwards, it will start. It will not be the scheme. The learned judge has been pleased to record, I shall come back to it, that it is almost as if the NCLT will take it up as a scheme application. No. It will be initiation of corporate insolvency resolution process under insolvency and bankruptcy. Two things are there. Three things, I should say. First is any party or parties to any proceedings relating to winding up. So the party or parties has to be a party related to, then only he is entitled to make this application. It's a may present an application. It's quite possible that they will not make an application. They are quite content with the matter being kept in the High Court. In which event, my lord, I will submit to your lordship 434 will not apply. So, my lord, your lordship looks into the proviso. Then, my lord, the imperative language of the main section is to a large extent watered down. Whereas, my lord, the main provision says shall stand transfer to the tribunal. Here, my lord, the proviso, when your lordship reads, may apply and the court may by orders transfer. And in fact, my lord, when your lordship looks into the provisos, all the other provisos, your lordship will be pleased to find that there is an element of discretion. It is not that all proceedings will go. Your lordship will be pleased to take, again, come back to C.
Or may apply, may not.
After, my lord, the main section, subsection C, kindly see the first proviso. Provided that only such proceedings relating to winding up of the companies shall be transferred to the tribunal that are at a stage as may be prescribed to the central government. Therefore, central government has been specifically conferred the power and the jurisdiction to frame rules and regulations for the purpose of, my lord, indicating which proceedings should be transferred and which proceedings not. Very first proviso, my lord, waters down, my lord, rather I should say, to some extent mollifies the language of the main section. And my lord, if your lordship, I don't know whether your lordship has got a copy of this. পাওয়া যাবে কিনা দেখো আজকে দেওয়া হলো তো আমরা এতগুলো কাগজের মধ্যে আছে হ্যাঁ এটা দিই this is my lord this is what, my lord, the central government had done. The first one is of 2016. This is 7th December 2016. Kindly come to Rule 5 in the notification. Transfer of pending proceedings of winding up on the ground of inability to pay debt. All petitions relating to winding up under Clause E of Section 433 of the Act on the ground of inability to pay, Section 433 of the 1956 Act, on the ground of inability to pay its debt pending before a high court, and, kindly note these words, very important, and where the petition has not been served on the respondent as required under Rule 26 of the Company Court Rules 1959, shall be transferred to the bench of the tribunal established under subsection 4 of Section 419 of the Act, exercising territorial jurisdiction, and such petition shall be treated as application under Section 7, 8, or 9 of the Code, as the case may be, and dealt with in accordance with Part 2 of the Code. So, my lord, here again, Section 7, 8, and 9 of the IBC, that will apply once it is transferred. And which matters will be transferred? Where the petition has not been served on the respondent as required under Rule 26. So, my lord, kindly now come back to the main provision. This argument I am making before lordship, I don't know, my lord, to what extent, my lord, it is justified. But, my lord, I have not come across any other case in which, my lord, this in this way, the analysis has been made with regard to the provisions of this particular section. Now, my lord, kindly come back to, my lord, subsection C again once more. After saying that all proceedings in arbitration, compromise, arrangement, reconstruction, and winding up shall stand transferred. The first proviso is saying only such proceedings relating to winding up of the companies shall be transferred to the tribunal that are at a stage as may be prescribed by the central government. My lord, kindly note one thing, one significant thing, that this proviso, first proviso, is only confined to the winding up proceedings. not with regard to proceedings in arbitration, compromise, arrangement, and reconstruction. First proviso is only confined to the winding up. Why, in respect of winding up proceedings, power has been conferred under this section on the Union of India, on the government, to frame rules.
Rule 5 is only winding up on the ground of inability to pay debt.
Yes, that's right.
Then Rule 6 is A and F,
Right.
the
Well,
other grounds.
therefore, kindly see, first of all, the main provision is comprehending so many aspects of the matter: arbitration, compromise, arrangement, reconstruction, and winding up. Again, in respect of winding up also, there is a division: an inability to pay debt and voluntary winding up. So, my lord, this concept of automatic transfer, my hands are tied, therefore I can't do anything, the matter, the act having come into existence, automatically it goes. No, that is not the case. That is not the story. Main provision has been, to a large extent, I should say, circumscribed by the provisos. I shall draw your lordship's attention to a decision on this aspect: to what extent proviso comes into operation for the purpose of interpreting the main section. The concept of interpretation of statute will come into.
And how far they can limit
How
the
far they can
operation of the
operation of the main. Well, the provisos themselves are limiting, they're restricting the operation of that. Therefore, my lord, I will submit to your lordship that kindly do not proceed on the basis that my hands are tied. Kindly do not proceed on the basis I do not have any discretion. Discretion has been given in the provisos, in spite of the fact that there is an imperative language in the main section.
Section shall should be read as main.
My lord, after this notification of 2016, there has been another notification in terms of, my lord, the first proviso. I do not know whether the lordship has got a copy of that.
we think so, 29 June 2017.
Yes, 29 June. 2017. There again, Rule 5. Here, your lordship says transfer of pending proceedings of winding up on the ground of inability to pay debts. All petition relating to winding up of the company under Clause E of Section 433 of the 1956 Act on the ground of inability to pay its debt pending before a high court, and where the petition has not been served on the respondent under Rule 26 of the Companies Court rules, shall be transferred to the bench of the tribunal established under subsection 4 of Section 419 of the Companies Act 2013, exercising territorial jurisdiction to be dealt with in accordance with Part 2 of the Code. Therefore, here again shall not be transferred under Rule 26 of the Companies Act, unless, of course, the petition has not been served on the respondent. If the petition has been served on the respondent, and where the petition has not been served on the respondent, so and so shall be transferred. So, my lord, at the initial stage, inception, the indication is this, that the government notifications, my lord, which have been issued from time to time, it seems, my lord, that if the matters have been proceeded with before the court, then perhaps they do not, the government notifications did not want to touch them. The government notification says in both the notifications that it shall be when the petition has not been served on the respondent, at that stage it will be served. It will be transferred. Where the petition has not been served. The same in, my lord, Rule 5, the earlier rule, and, my lord, in the subsequent rule. My lord, apart from this, my lord, these I am going to
issue notification specifying the stage which it will be transferred.
Okay, IBC code that peculiar registration. তাহলে কি একবার সার্ভিস হয়ে গেলে ট্রান্সফার হবে না? হয়তো ট্রান্সফার হবে না, এখানে তাহলে সবই কিছুই ট্রান্সফার হবে, সার্ভিস হয়ে গেলে ট্রান্সফার হবে না। অ্যাবসার্ড লাগছে, এফিকেসিটা কোথায় গেল? But then nothing will be transferred if you go by this. Once it is served on the company, the petitioning creditor. Take your lordship to the other provisos. There is some kind of, well, unfortunate thing is this, that from time to time, my lord, these notifications are issued, and my lord, the provisos that there. One will have to sort of dovetail all these things, and together one will have to read. In fact, your lordship is perfectly right. Looking into proviso 1, it seems that, and read with my lord the
Notification, yes.
that your lordship says, I am not reading anything more. I am just reading, my lord, literally, my lord, what is there. It gives the impression that if it has not been served, then only you can transfer.
You don't have to go to the stage of irreversibility.
Yes, exactly.
The service is enough.
That's what I think.
That's absurd.
I think, my lord, what the Supreme Court said is this. Supreme Court concentrated more on the first part of the section, not the provisos so much. And my lord, in any event, I say that this, if one reads only the main provision of subsection C, one is, I mean, left with absolutely inescapable conclusion that it shall stand transferred.
Yes.
This is the indication.
Yes.
But subsequently in 2018, the proviso which came into existence gave complete power in the hand of the court. Court may. Discretion of the court has been given. Why should I, my lord, curtail the discretion of the court when the section gives that power? Why should I confine myself to irreversibility? There may be situations when your lordship may find that it is inequitable to transfer this and put the entire proceedings into a completely different procedure. Your lordship, otherwise, well, what's the meaning of the court made the order for transfer?
In a way, our hands are tied, Mr. Mitro. Our hands are tied to the extent that we have to rise at 3:30. So
that is the only restraint on your lordship discretion.
Next Friday নাকি? একদিন বসবি মাঝখানে 3:30 সময়. We can keep it on a day other than Friday at 3:30.
Yeah, any day your lordship have.
My lord, any day, my lord.
You were right now here. Where are you now?
My lord, I was here, my lord. I also informed, my lord, Mr. Mitro, that I wanted to know, my lord, whether he'd conclude today. He said,
No.
my lord, he said
Very
no.
well.
So,
Very well, Thursday.
No, I told him.
Thursday 3:30.
I told
Hey,
Mr. Mukherjee this, that you can go away. And
দেখো কৌশিক.
And I told him that you can be rest assured that until you come back, I am not going to conclude.
no, my lord, I heard the arguments. My lord, I was online. I heard, my lord, the arguments right through.
Oh, you are leading Mr. Banerjee?
Yes, my lord.
Mr. Joyanto Kumar Mitro, learned senior advocate, representing the appellant, representing Indo-Wagon, Indo-Wagon, huh? Indo-Wagon. Resumes his argument but does not conclude. Paragraph. List these matters once again on Thursday, date the
26, I think.
Marked 3:30 p.m. Next Friday, কিন্তু বসবো.
After Mr. Mitro finishes, I will have to address your lordship. For the workers, after Mr. Mitro finishes, I'll have to address your lordship.
You are also opposing transfer.
Yes.
And Mr. Surajit Nath Mitro?
He is also opposing.
He is also opposing.
I will not be there on the 26th. Well, I am expecting Mr. Mitro will carry on. That is my instruction, sir.
Very well.
My lord, my lord,
3:30
my lord, one indulgence, my lord. My lord, since this is a specially constituted bench, my lord, the other assigned matters, my lord, shall they be again
They'll
listed?
be added as and when they are assigned. They'll all be added to this list.
Yes, my lord. My lord, will this bench again be sitting
We'll
next
sit every
Friday?
week.
Oh, grateful.
Next Thursday.
Grateful.
Yeah, sure.
Obliged.
Sure.